Supplementary cause list, pronouncement of judgment.
Read out the operative part. In view of the above, the impugn judgment and order of the conviction dated 17/4/2023 and order of sentence of event date passed by the Learned Session Judge East Jayant Hills District Lariat in session case number 11 of 2020 is set aside and quashed. The appellant is set at liberty forthwith if not required in connection with any other case. The criminal appeal stands allowed.
I do pledge your lordship.
Yes.
Any mention?
Yeah, please, lordship. I beg to mention item number 8, lordship.
Yes.
Yes, so lordship, in this case, I had been engaged as a legal aid counsel. So I had been this case has been withdrawn from me, and private counsel has entered up.
Lordship, I'll be filing my wakalatnama in the course of the day, Lord. My Lord.
Okay. Just say.
After how many?
But then just wait for the matter to come. Who is the other side? Then what would be your prayer then? You'll take up the matter today.
No, my Lord. I'll take time, my Lord, because I don't have the paper book and everything with me, my Lord. I will have to take it from the registry.
Mr. S.T. Padai, Learned Legal Counsel, submits that he is no longer a counsel for the appellant. He will no longer represent the appellant in this matter. As your name, M.S. So-and-so, has been engaged as counsel for the appellant. So, then you write, Miss So-and-so, please for grant us some time.
3 week time, my Lord.
Hear the matter. State has no objection. Prayer allowed. List after 3 weeks.
Highly obliged.
Please, your lordship, I beg to mention item number 12, lordship. Item number 12, lordship.
Item number 12.
12. I pray for 2 weeks time, lordship. Here.
Yes, you
I
are
have
for
some
the
difficulty. I have for the respondent number 2, lordship.
there is a private respondent.
Private respondent.
Private respondent.
Yes, what do you want?
Yes, lordship.
What do you want?
2 weeks, lordship.
No objections, lordship.
12.
12. On the request of the request made on behalf of the private respondent number so and so. List is met after 2 weeks. Okay.
Highly obliged.
Yes.
May I please, your lordship? I'd like to mention item number 10.
Yes.
Your lordship, I pray for 2 weeks time, your lordship, due to unavailability of...
You are appealing for the respondent.
Yes, lordship. Respondent number 2.
No objection, Your Lordship.
2 weeks.
2 weeks.
This also.
Item 11 is a connected matter, your lordship.
Item 11.
10
also.
and 11.
10 and 11.
Yes, lordship.
Same set of counsels.
Yes, lordship.
Both for the state also. You are there in 10 and 11.
Yes,
Both the matters.
Learned AAG, Mr.
No, but then you are also there assisting him, isn't it?
Yes,
At least right now you are representing the for state, is it?
States.
Okay, 10 and 11. And then you are private respondent there in both
Yes,
the
lordship.
matters. Just say 10 and 11. After 2 weeks on the request made on the other private number so and so. Okay. You can write it like this on the request made by the council for so and so. This is better. 2 weeks. Okay.
Highly obliged, your lordship.
Yes. This court is waiting for you. Why?
That's why I beg to make a mention for item 5, lordship.
Item 5.
Yes, lordship.
What happened?
I'm praying for 2 weeks time, lordship.
Why?
Senior counsel is having some
This is
difficulties.
what is the matter about?
Squashing of the proceeding, lordship.
CR case.
Yes, sir.
The other side. Who is the other side? The state.
First,
There is no private private party here.
No, lordship.
no, just a state.
This is quashing of FIR. It means.
It's the entire proceeding, lordship.
The matter has been charged sheeted and this trial has it been charged sheeted?
Yes, Your Lordship.
Any interim order here?
No, Your Lordship.
Okay, item number 5. On the request made on behalf of the petitioner, release this matter after 2 weeks. Yes.
Similar prayer for item 6 as well, Your Lordship.
This is the bank matter.
Yes, Your Lordship.
Defaulter.
Willful defaulter, Your Lordship. Yes.
Why you keep this matter pending? Just see what purpose. You see what purpose it serves. If you want that stigma attached to you should go, you should be basically coming up for urgent hearing of this matter. You are repeatedly taking time.
No objection, Your Lordship.
6 after 2 weeks on the request of the petitioner.
We are blessed.
Yes.
Daily cause list. Item number 1.
My lord, we have prepared the paper. Can come and submit. Take time. Take time. Can come and submit. It's a lengthy petition.
Yes.
My lord, I'm submitting the list of dates and the paper. Your lordship allowed me to do that in the last occasion.
Yes.
My lord, instead of going to the numerous annexures in the pleadings, I have compiled it chronologically, the relevant one. This will answer the contention raised between the parties.
These are
here.
all part of documents of
Yes, yes.
writ petition.
Yes, I lifted
not-
from the writ petition.
Not incorporated any
Yes,
extra document.
I lifted from the writ petition as well as from the affidavit filed by the other side. It's a compilation. Now, straight away, my lord, I'll come to page number 1
Of the compilation.
of the compilation. That will shorten the, my lord, the
controversy.
the controversy. Now, page number 1 is the appointment order with regard to respondent number 7, Shamsundar Rai.
Just give us a brief of the thing, the story of the case. Just
My lord, now what happened, my lord, the school was established and initially 4 teachers were appointed, and subsequently, my lord, the one of the science teacher in 2014 resigned. So since he resigned, managing committee called for a meeting and recommended my name for appointment in the science subject. So this was forwarded to the STSU for approval. So it took some time, and subsequently provisional approval was granted under the SSS scheme. Then I received some salary and they stopped. Now the main hurdle was created by the private respondent number 7, who is the secretary of the managing committee. His contention is that I was not part of the recommendation and I did not issue appointment letter to you, so I don't recognize you. So my salary was withheld. I put up this issue before the district mission coordinator. District mission coordinator directed the managing committee to release the salary. He did not. Therefore, I filed a writ petition, and during the pending of the writ petition, the writ petitioner and the respondent number 7 reached a compromise without involvement of the state. And the respondent number 7 admitted that yes, now I recognize you. From today onward, I recognize you as a science teacher. I will release the salary along with the president of the managing committee. So you go and withdraw the writ petition. So he came and withdrew the writ petition after signing the agreement. And after agreement was reached and writ petition was withdrawn, 18 months salary was released. Subsequently, there was a change of managing committee, and managing committee took the plea along with him. Then, that agreement was signed under pressure. He did not file any FIR. Therefore, managing committee adopted a resolution and appointed him as a science teacher, and removed me from
appointed whom?
appointing the respondent number 7, who was appointed as a headmaster in the school.
He had settled the matter with you.
Yeah,
On
he
the
has
basis
a-
of settlement, you withdrew that writ petition.
Yes. And they have released, managing committee
But
had
then he
released.
was already there in that school, isn't it? So where is the question of appointing him against?
That is my now the issue came. Now he was appointed for headmaster. Now the SSA policy came into being, and the authority prescribed that under SSA school only 3 sanction posts are there. One is social studies, language, and mathematics and science. Now coming to
Four
know,
posts or 3?
yeah, three only. Social studies, language, and science. Science comprises of science and mathematics. So 3 sanction posts. Now realizing that he is not holding any sanction posts, therefore he claimed, and he was appointed by the managing committee.
So with the time when he entered into a compromise with you,
Yes.
He was not holding a sanction post.
He was holding the headmaster only, which is not a sanction post.
So he himself was not holding a sanction post and entered into
Yes.
compromise with holder of a sanction post.
Yes, yes. Only he was exercising.
Who had the superior authority that way?
My lord, he was exercising as a
Now these are something very unusual things.
my lord.
It's something like a temporary teacher accommodating a permanent teacher.
Madam.
Something like that. It sounds like that.
Being a founder teacher, and
So anyway, after that thing, then managing committee changes. Then they say that earlier compromise was obtained under duress, and then they refuse to give you salary,
yes,
and they take that
Yes.
other person,
Yes,
the person who compromised with you,
yes,
into your post.
into my post,
Yes.
and reduced me into a fourth teacher, and fourth
But
teacher
then you said that your candidature was provisionally
approved. For it. It was approved. For it.
so this approval by the state.
Yes, sir, by the
So
STH.
that approval has never been
Cancelled earlier during the managing committee resolution, removing me from the post. My provisional approval was subsistence, and the STSU passed an order that I am disqualified because I failed in mathematics, and subsequently he passed an order that my provisional approval was cancelled because my appointment was against the rule. Now, which rule they did not disclose.
But then that means it was cancellation is there. Rightly or wrongly, we will see later.
Yes.
But then cancellation is there.
Yes.
The cancellation of the approval is there.
Yes.
Now, what is the date of that cancellation?
2018.
2018.
2018.
And when this respondent number 7 was taken into your place?
Yes.
After that, when? After
Before-
2018 or?
Well, before my cancellation, he was appointed. Like the two appointment letters also there, his
Before
approval letters.
approval of your cancellation,
Yes.
he was taken and with that post.
Yes.
And was it approved by the state?
Approved by the state.
When?
Provisional approved 2018. 2018.
What is prior or what is later? Your
Now,
cancellation?
my cancellation, my lord, his appointment was prior. My the disqualification was prior, and subsequently my former cancellation order came without issuing any notice. So I'll come to that point. And admittedly, managing is the
That seems
authority.
very confusing.
Therefore, if my lord, I'll take my lord attention to the
Definitely, we'll come to the
pages.
documents. Just for the purpose of proper appreciation, this court requested you to place the fact
Yes.
so that you can apply mind. You see, like. Anyway, now.
So
you are challenging that action.
yeah, that action also. Now my
The respondent number 7 is before us.
yeah before
The managing committee of the school
before my lord.
is also
The
before
other
us.
party. The other party.
You are the managing committee.
Yes, he's
And
representing.
who is respondent number 7?
Seven is the Mr. Right. He represents for him also.
7 and managing committee.
Seven in managing committee. He is representing. Now my basic question. My issue is, my lord, the appointment order was issued. Sorry, the cancellation order was issued without issuing show cause notice to the petitioner. So it is not tenable in law.
Now,
And-
once what the scheme under which your service was approved, what does it say about the service condition
My lord, this
of
is
a teacher?
under the SSS school. Normally, my lord, this is at the upper primary school or primary school. Here, the SSS scheme came into being under RTE and strengthening the schools. So some of the school would receive infrastructure development, some would receive a grant so that they can bear the salary for the teachers. Now, in this Larmity school, they receive a grant to sponsor the salary of the teachers.
See, since there is a system of approval,
Yes.
so far as the appointment of teacher under the scheme is concerned,
Yes.
the scheme must say something about the induction of teachers.
My lord, this appointment of teachers or suspension is governed by the
Where is
state
the scheme?
rules.
Where is the scheme? Do you
My
have?
lord, the scheme is not there, my lord. Scheme is not there, but scheme is only for
You have a
granting.
copy of scheme? Anyone? Any
My lord, Mr. Abraham would know, my lord, is the author of the scheme.
scheme of the Sarva Shiksha
Yeah,
Abhijan
up-
scheme?
schemes.
Does it say anything about the induction of teachers into service and all.
This matter is been led by Karmi. He's conduct before another court. He'll be joining shortly, so he'll be the right person.
These are basic information. You can say that, Mr. Abraham, you have a long standing.
So
This is general question, not particular to the facts of this case.
regarding this particular case,
No, then scheme becomes very important if it is to be decided on that. We have to see, we have to determine the rights and duties of the parties on the basis of the scheme, stipulation made in the scheme. If it is silent, then we will apply the general law, the principle of natural justice.
IT 2009 will be applicable.
That
Right
is
to
okay.
education.
What the scheme says?
It is scheme says that a teacher should be appointed after 2010. On following the procedure, that there should be advertisement for appointment of teachers. But in this case, it was silent. In this matters, they didn't.
That is okay. But then see, you have not cancelled his selection on the basis of, did you do that on the basis that there was no valid advertisement at all?
We have challenges.
You have said that.
We have
His
matters.
his termination, order of termination, does it say so?
Termination
What is the
order
scheme? Do you have a copy of the scheme?
scheme issued at least.
But we would produce, but the issue.
If somebody is appointed under a scheme, it was your duty to at least append it with a writ petition or say at least carry it with you.
But
Just to satisfy the court that there exists no condition. Something would be said, how service will be taken. You see, it cannot be something like that the government will pay money to a school without saying anything.
well, here the impugned order, they are not referring to the SSS scheme. Only they say that I failed in mathematics in one impugned order, and the second
But then
impugned
your
order.
induction in the school is under the SSS scheme, your approval is under the SSS scheme.
But approval, my lord, approval is under the rules, appointment also. Now, the SSS scheme only operates in a limited area, that is granting, extending grant.
Nothing else.
Yes,
Then
it
why
is.
do you have a system of approval by the state?
My lord, that is under the, my lord,
Then it should have,
Meghalaya
been,
Education Act.
should have been by the school only.
My lord, Meghalaya Education Act, my lord, 1981.
No,
I'll place it.
the Meghalaya Education Act is so far the school which is receiving aid under the state, from the state.
My lord.
But then it has nothing to do with Sarva Shiksha Abhiyan. Sarva Shiksha Abhiyan is a centrally sponsored scheme.
It is
And then you are getting approval from the coordinator, mission coordinator and all. These are all functionaries under the scheme.
my lord. Therefore, this is a private school.
They may be state government authorities. But then under the scheme, they are functioning discharging duty. There are two differences. Receiving grant in aid from this state and receiving grant under the scheme. There are many schools which are receiving grant even they are
Without
not under this
SSA
scheme.
also.
Yes.
Without SSA, the grant is there.
So that is
The grant is two.
the
two
school
grants.
education act will apply in general. You see, it's a general application. But then if somebody says, supposing if you are a teacher under the scheme, when the scheme is discontinued, your service also goes.
Right.
Then you cannot come and seek defense of the School Education Act that I have not been given a shock cause, that this thing, all those things. You cannot come. So that is where the difference lies there. So that is what this court is interested to see. If scheme contains certain specific, then the condition of service of any teacher under that scheme will be guided by those specific conditions. We will not see outside the scheme. If it is not there, then only we will come travel outside. This is what the law is. Mr. Abraham also is not in a position, the person who is implementing the scheme is not in a position to say that whether scheme contains some stipulation with regard to service or not. Why a teacher is required to be approved under the scheme? Is there any stipulation in the scheme?
but because I'm not really. If this matter can be taken up by Monday next week.
The 2018 matters.
Monday or it come up tomorrow.
You want to say that scheme will not throw any more light into the matter?
My lord,
It will be irrelevant.
my lord, the scheme has a limited role to play, and they are not relying on the.
And then you want to say that scheme has no provision with regard to the service of the condition of service of the teacher.
My appointment and a remover.
Seems very unusual.
It is a private
See,
school recognized.
appointment and removal, because of some disciplinary action, it's a different thing. But then otherwise, the approval, if you say that the person has to be approved, then it is implied, there where it is implied. And let us proceed for some time. Let us see if there is any real difficulty, then we will take it up on it.
Well,
yes.
So page number 1 is the appointment. Well, on recommendation of the managing committee of the Larma DUP, school is hereby approved. Sri Sundar Rai, he is the right response number 7, as headmaster. And Sri Hamidur Rahman, science pass. He resigned, he's the one who resigned, science teacher, and Sordana Sansach, pass assistant, and Sansajan, 4 of them appointed Hindi teacher. Now, later on, my lord, page number, second page, number 2, that Hamidur Rahman was resigned, and because of the managing committee called for a meeting on 25th April 2014, page number 2.
When did he resign?
Now, my lord, his resignation is, my lord, page number 3, resolution number 1.
Okay, page number 3.
My lord.
That is reflected.
After thorough part discussion, the House of MC unanimously resolved and accepted the resignation of Sri Hamidur Rahman, science teacher, by resignation letter, such. Therefore, the House of SMC Larma UP school resolved to select a local candidates with high experience to fill up the post of science teacher, and under reference, Sri Nurul Islam high school science pass is hereby selected in the vacant post of such. So he was selected. Nurul Islam is the petitioner. And thereafter, my lord, page number 4. Appointment letter was issued to him, 2nd May 2014, by the president of the.
You are Nazrul Islam, isn't it?
Well. Was issued by the president of the managing committee, and there was my lord, refusal to release the salary because of the secretary. Now, page number 5.
Now, this is a resolution of 2014.
14.
Now, we are taken into service by a resolution of 2014.
14, yes.
When the scheme came into existence?
But the scheme is prior to this. Scheme is prior to this, my appointment.
Even in 2010,
yes,
when those 2 persons were arrested, the first and page 1, the scheme was there.
The scheme was there, but perhaps it was not recognized. The scheme was not extended to the private school. This is a private school.
That is okay, but then the scheme was there. Then when this, see, so far as you are concerned, the day on which you are taken under the scheme, that means like that assumption will be that you brought under the scheme on such that day. Okay, so far the existence of scheme is from that day only. Now, when this school was taken under the scheme?
My lord, it appears that page number 3,
yes,
resolution number 2,
yes,
it reflects the SSA one. Now, up resolution number 2.
It is SSA. Now, when it was taken under SSA?
My lord, that particular instruction, I'm not aware. And the school was kept under.
So many informations are missing in this matter, Mr. So far as the requirement of court is concerned.
But
this court doesn't want to miss a single information.
My lord, that aspect SMC is here. They can disclose for lordship satisfaction.
Yes, SMC can give that information.
Yes, it is there.
When the school came under the scheme? When the school came? Which date? Mr. Shangresh, you are referring to which part of the resolution, page 3?
Page number 3, resolution number 2. After prolonged discussion, lordship, the House of Managing Committee empowered the President to appoint
salary as per SSA.
Yes, local candidates with salary as per SSA norms.
Now, as per SSA will not mean that equivalent rate.
So
now,
this is
if we say as per, will it mean under?
But no, they are not disputing. They are not disputing this application of SSA in the school. And because of that, my restriction of a number of sanctioned posts also came. And
they may appoint a teacher outside the scheme, and they say that we will confer all the benefit of this.
They can do that also. They can.
So that is what means here. If you say as per SSA.
Now this will be revealed in the subsequent pages. What is the nature of the SSA application at the school? Now, page number 4 is my appointment.
Yes.
And
This is by the managing committee.
Managing committee president. Now the number 7, respondent number 7 said that appointment order should be issued by secretary. Now thereafter page number 5, I put up a representation to the authority, and the authority discrimination coordinator has issued this letter. And in the last portion, may I read out? You are therefore requested to look into the matter and instruct the headmaster cum secretary to release the due amount of salary to the concerned teacher immediately. So this was directed to the Joint Discrimination Director.
What is the date? This is the date.
This was, my lord, 21st December 2015. So
That is one.
DMC,
More than 1 year after.
yes, DMC directed the Joint DMC to direct the headmaster, that is secretary, that is respondent number 7, to release the salary. And page number 6,
Just a minute. Just one second. Now, what is that resolution of 6th July?
Lordship is
Or
reading
6th or
to,
6th representation of 6th July by the managing committee?
my lord, this is, since it is a complaint dated 2nd July. My lord, I'm not aware, copy was not served upon him
This
also.
is say mentions a copy of representation 6th July 2015 received from the members of the managing committee. In this letter dated 21/12, this page 5,
Yes.
in the material you will find there is a mention of a copy of representation dated 6th July 2015
Yes.
received from the members of the school managing committee. Have you got it?
Lordship is
At
reading
page 5 of your
page 5, yes.
compilation.
All right, my lord, in this case, it is
Yeah.
mentioned that copy of the representation dated such received from the members of the school managing committee was forwarded to your office for taking necessary action.
Yes, so what
My
is
lord,
this?
this representation, my lord,
The first paragraph speaks about your representation.
yes, yes,
Second paragraph speaks about school managing committee's
my lord, my lord, my lord,
It is forwarded by a common letter.
yes.
Are they connected?
My lord, here we are not aware, my copy is not served upon him, so he is not aware. My lord, whether SMC has put up this representation.
No, that is, since it is forwarded by the same letter now, that is what the problem is. Anyway, proceed. Just.
Now, page number 6, now the respondent number 6,
Then-
no, number 7,
There, after this forwarding of these, what happens? 21/12/2015?
yes. Thereafter, my lord, the respondent number 6 has put up a representation to the DMC, page number 6,
Respondent number 6.
number 7.
He was the
He was
headmaster.
holding the post of a headmaster, and he has filed a complaint or
He
representation.
was
for the-
headmaster plus the secretary of the managing committee.
Yes, yes, yes. Now, page number 6, Lordship. His complaint is 22nd February 2016. Subject reply to letter dated. My lord, he is replying to the page number 5 letter. Page number 5 is the letter dated 21
Yes.
December, and now he is replying to that. By page number 6, he is replying. Now, when he reply, may I come to the point number 1 in the middle. As per recommendation of the then managing committee, my lord, of Larmiti UP School, the then joint district mission coordinator appointed the following 4 teachers as follow order 1/9/2010. The first page number 1 I read out, my lord. Now, Sundarai, he is the one, my lord, headmaster. So he do admit in 2016 that he was appointed for headmaster, not for science teacher. And science teacher, my lord, he did not mention
A
his,
science teacher cannot be a headmaster.
my lord, because a science teacher,
Somebody will have to be there as administrative head, isn't it? Now, say supposing in a school where there are only teachers under the SSS scheme, Now teachers will definitely, one will lead literature, one for science,
Yes.
one for mathematics. Then one will function as head teacher.
Head teacher.
So just by mere mention of head teacher would not mean that he is not a science teacher.
My lord, he was not a science teacher because he did not have a science qualification.
He is BA.
Yes. Now, subsequent pages will reveal that one. And now he suppressed Mr. Raman. The science teacher appointment also he suppressed. In page number 1, I pointed out, my lord, Mr. Raman was appointed for science teacher. In 2014, he resigned. Now, Sundara is suppressing that one also. Now, this was his reply. So, the next page, number 7.
Now, this paragraph concerns you, isn't it?
Yes.
That Nazrul Islam claiming a science teacher of
Yes.
so-and-so.
Yes. False and baseless claim. He has neither appointed by me. Lordship, see the language. He said he has to appoint by himself. Or appointed by the Joint Distribution Coordinator.
Yes.
It is the fact that Nazrul Islam was approached to the SMC to serve in the school without any salary for a few minutes. So that was it. That was his ground. So he was disputing my appointment.
Now, he refers to resolution number so-and-so dated 17/1/2014.
Yes, my managing committee resolution appointment.
Now, does it say that you should be serving without salary now?
No, my lord. I should be appointed as per the SSA. That is the terms of the recommendation by the SMC.
But then what makes him to say this one? This is
That is why, my lord, he was
he
disputing.
refers to the same resolution.
Yes, yes.
But then this is resolution 1. You said your thing is resolution 2 there.
My lord. So therefore, the SMC resolution never says, page number 3, Worship, page number 3, SMC resolution, resolution number 1 and 2, page number 3. This thing. Number 1 talk about the resignation of Mr. Raman, former science teacher, and my appointment. And number 2, my salary should be as per the SSS norms.
Now, if you see his reply, in page 6, he refers to managing committee meeting resolution number 1 dated 71/2024 or 2014. And if you come back to page 3, then you see your appointment is by resolution number 2.
Yes. 1 and 2. It should be 1 and 2, read together.
No,
One is
but
my
then his
appointment.
reference there is only 1.
Yes. He quoted only one, resolution number 1. He quoted.
That is what. Is there any other? You see, it is very difficult. Whether this document given by you, has this document has been disputed? Not disputed.
They are not disputing. In effect, they are not disputing. They are not disputing.
So this is one thing they will have to reply it.
Well, they are not disputing in the affidavit. And Lordship, thereafter he has given reply, page number 8. District Mission Coordinator has issued this letter again. Page number 8. Page number 8. Now, he made it very clear about the sanctioning of a post for the school. Now, in continuation of this office letter as referred above, it is stated again that as per PAP approval, every upper primary school sanctioned under SSA shall have one language subject teacher, one teacher for science and mathematics, one for teaching social studies. In this connection, it is to mention here that the approval of teachers at Larmati SSA as answered by your office without science or mathematics teacher is against the norms and approval of the SSA and RTE.
So what is the norms? This reverts to norms. What are the norms?
No, this is the guide.
Now you say that there is nothing is there. Now if you see this paragraph in connection, it's mentioned here the approval of teachers at Lalmati SSA school EPS by your office without a science and mathematics teacher is against the norms and approval of the SSA and RTE. Now what is the norms? How do we get the norms? What is the laid down norms?
Well, the norm is not annexed here because it was never disputed. Well, there is no controversy with regard to norms.
Non-dispute doesn't establish something
Mr.
to be,
Kami
to
can
be as
produce
this thing.
your
It will be a
lordship
mistake
desire.
by them, but then it will not become a norms.
Right.
There indication is that there exist norms. How can without norms a person be taken into service?
Well, I pray if Lordship desire, my friend can produce the norms.
No, they will have to see somebody will
Lordship
have to
desire.
produce the norms.
Otherwise, they are not disputing.
What are the norms for appointment under SSS scheme?
The norms is that there are 3 section post teacher and SSA.
What basis you say it?
Lordship, that is
What is the laid down? Where this laid these things? Where it is laid down? These norms are laid
that
down.
one I'll have to obtain the instruction whether it's
Please
there
you
or not.
please you obtain, you place it here. Otherwise this court will not be able to appreciate it properly. It also says about norms. You'll have to produce it. Anyway, Mr. Sangaresha, yes.
My lord. So, in the last portion, my lord, in the above circumstances, you are hereby requested to review the approval of teachers at Larmati, considering the appointment of Mr. Nurul Islam, science teacher, and payment of salaries accordingly, and submit the action report to the undersigned immediately. So, this was written, and thereafter, my lord, nothing was happened.
Then what is the meaning of this letter?
But this letter,
Now,
my lord,
if you say that you are appointed in 2014,
yes,
okay,
yes.
then why it should say to review the approval of teachers?
But because there was a approval, page number 1. Page number 1, approval of 2010, comprising of science teacher and 4 teachers.
That we do not know whether that approval is under SSS scheme or not. That is why, that is the prime question, Mr. Sangaresha. There remains huge confusion now. If you refer to the 2010 letter, by which the respondent number 7 and the person who retired were appointed, there is nothing to show that they were under SSS scheme.
But it is not mentioned. It is not mentioned there.
You say that you entered the service in 2014.
Yes.
And subsequently there is a provisional approval to your.
But till this stage, 2016, my approval not yet come. Not yet come forward.
You are serving, and then till that period, what salary you were getting?
I did not get salary. Therefore, I put up the representation.
So that means that way the contention of that person that you were appointed without salary, that is correct.
That time salary was not given. But appointment order never says that I was appointed without salary.
Something is fishy. Something is.
Now this is my lord, the letter. Now the DMC has clarified only 3 sanction posts are there.
Now, one second. If you go by the language of this letter,
yes.
In the above circumstances, you are hereby requested to review the approval of teachers.
Yes.
That means there was one approval, and this letter 6,
yes,
review of that approval.
Yes.
Now, what was the approval on that day?
My lord, that approval, my lord, I'm not aware, my lord. I'm not aware.
These are the crux of the things.
No, my lord, the contention of the respondents is not on this. They're not disputing. Sanction post, they're not disputing.
But then how will get a clear picture of the case?
But according to me, the annexures which we have we prepared.
Then you are asked to review the approval.
Yes.
It means there was some approval in existence, and by this letter, review was sought.
Yes.
Then what happens?
And nothing happened there for page number 9. My lord may travel to page number 9. Letter dated 27 May.
Now, if there is nothing on record, how could you interpret this letter in your favor? How do you say it is for the purpose of accommodating?
I don't say, my lord, this letter is in my favor. My submission is that this letter was issued to direct the subordinate officer to review the records properly. Now, subsequently, the next page number 9.
Yes.
The same authority issued this letter.
Yes.
Since nothing was happened.
The earlier letter was dated 16/3/2016.
Yes.
Now this is 27/5/2016.
Yes.
From the same authority to the
same authority.
Okay.
Now, in the middle, may I read to save lordship time? It is once again reminded that as per the project approval board, Government of India, each upper primary schools and the SSA shall have one language subject teacher, one teacher for teaching science and mathematics, one teacher for social studies, and the fund for payment of salaries to these specified teachers are accordingly approved by the PAP also. In case of Larmati and such, one Hindi teachers, 4th teacher is approved through state funding. You are there requested to expedite the process and submit action report on the above matter to the office of the undersigned without fail. Also request to submit a copy of the approval order of teachers of Larmati and such. So he sought for that after clarifying the sanction post. Now, subsequently, my lord, page number 10, my provisional approval came after reviewing the records. It says, as per recommendation by the MC of the Larmati School, such and such, 2014, an appointment of such and such, Nusrul Islam, is hereby provisionally approved by Sri Rahmatur Rahman, science teacher, resigned.
So this is in 22/6/2016.
Yes. So my approval was, and they are not disputing this.
Now, they approved that appointment of 2014.
Yes.
The first one, which you that resolution which
Yes,
you referred
yes.
to.
Yes, yes. Because the appointing authority, selection appointing authority is vested with the MC, and the government is the approving authority, STSU, the authority. Therefore, the approval was granted, provisional approval was granted. And thereafter, page number 11.
After yes.
Page number 11. Still then, salary was not released, therefore, the MC, same authority, directed the headmaster, cum secretary, and the president. Now it says, please find enclosed with copy of such and such.
This is dated immediately, not even after 1 month also.
Yes.
Of the previous order.
Yes, yes.
So you were appointed only a few days back, you were asking for salary.
He was teaching. He was teaching in the school.
Your approval is not with effect from any backdate.
Backdate is not given, but my lord, if the teachers are teaching.
If it is not there, how can this court will construe it? We will take it from the date of your approval only.
But even if, my lord, normally if the teachers are teaching, the sanction comes later, the benefit granted to them. Assuming that, my lord.
In such a case, that sanction would say that has been approved with effect from such and such.
They can do that. They can do that.
We cannot read something which is not provided.
They can do that, my lord. Since it is not with retrospective effect, it may be considered as a prospective effect. But the letter issued by the authority.
Now, your appointment is dated 22/6.
Yes.
And say within around 23 weeks.
So yes, 3 weeks.
Letter comes.
Letter comes for issuing the releasing the salaries. Because the DMC appreciate that he was teaching. This was the letter. And in response to this, another, this page number 12, Mr. Sundarai and some other, they have put up their grievances also, page number 12. They say non-payment of salary to teachers of Larmati School. They also say that the salaries are not released.
This refers to a representation by you, isn't it? This page 11.
Page number 11, yes.
Yes. What is your representation?
Well, representation 11 July 2016 received from such and such.
Also find enclosed here with a copy of representation received from Sri Nazrul Islam regarding non-receipt of salary by petitioner and other teachers of your school.
Yeah.
Now, where is that representation?
Well, the representation is not the
You
next
claim
year.
your salary from which date by that representation?
Well, he perhaps he claims from the day of his appointment. Even if, my lord.
You make a submission by saying perhaps. The opening word is perhaps.
Well, my lord.
Which way this court will take into your submission?
Lordship is forensically examining the paper. I appreciate, my lord. But it is not the grievance of the state also.
Well, you find this court is going for this forensic
thoroughly examining the matter, my lord.
It is not that. You see, like we want to determine what your actual claim is.
That is true. That is true.
There is no norms. Nothing. You are appointed 2 years back. 2 years you run without salary. After 2 years your approval comes.
Yes.
That also without retrospective effect, anything to show. But then you claim your salary.
Yes.
Now the automatic question is that if that school has a sanctioned strength of 3 teachers under the scheme,
yes,
from 2014 till 2016, the period for which you served, whether there was a disbursement of salary for 3 teachers or for 2 teachers.
Now, therefore,
you see, one wrong order by the court can create many problems. Now, if that fact is not known to us, now if it is there that already 3 teachers' salary was disbursed, you might not have received it, but the 3% was received.
Right.
And in addition to this court says that no, you have to pay salary to him, then where from that money will come?
My lord. Therefore, the page
So
number
that is
12
why
of
you
answer.
see that forensic examination thing is needed.
Needed. But therefore, Lordship is doing, I appreciate. Therefore, the answer, Lordship queries answer by page number 12. Page number 12.
Page number 12.
Page number 12.
Yes.
Mr. Sundar Rai also say that in others teacher, they are not receiving salaries.
Okay.
So that is the grievance. So, salaries are withheld.
No, if a person's teacher, if a teacher's service is not approved of the scheme, what is the question of receiving salary? Once it is approved, it is only with effect from the date of approval.
If it is not spelled out, retrospective nature.
That also will be that of approval, if that
specifically says. Otherwise, claim of salary will not be there. Just because you make a claim, doesn't mean that you are entitled.
Correct. Lordship would definitely appreciate the materials on demand. Now, this is the letter 20 July 2016.
Yes.
By Mr. Sundarai and others. So they also claim that their salaries are not released.
There are 3 other teachers.
Yes, 3 other
your
teachers.
Your letter, which has been referred in the previous speech,
yes,
it says that is a representation about non-receipt of salary by you and others.
Yes.
These are the same set of teachers.
Well, I did not, my lord, the writ petition did not address the grievance of other teachers. He is confined to his own grievances.
But then if you see the reference of your representation.
Representation 11 July, Lordship received from the Indo Islam.
In this letter of 14/7/2016, it says the last line of the first paragraph, also find enclosed here with a copy of representation received from Nazrul Islam. You got it?
Lordship referring to page number
11. Page 11.
Page 11, yes, I'm there, madam.
You got it? Also
I got it.
Find enclosed?
Yes.
Here is a copy of representation from Nazrul Islam regarding no salary by the petitioner and other teachers of your school. That means there also exists one representation written by you and some other teachers.
My lord, please enclose here with.
That is the fact stated there. You see, it is nothing. The court basically is getting an indication that there is a dispute between 2 sets of teachers. One may be perhaps with you who filed the application there for salary. And second is which you referring in that page 12.
Page number 12, yes, Mr. Sundarai and others.
See, there are 4 teachers, your name is not there.
Yes.
Isn't it?
My name is not there. My name is not there.
So,
but
what is the presumption? There are 2 groups of teachers. Not only you versus others, there are 2 different, isn't it? Different groups.
Well, it appears that 3 petitioners, 3 teachers also with Mr. Sundarai. But admittedly, none of them claim any rights.
That is
They
okay.
just
We are
put up
not
the
deciding. We are
representation.
not deciding anything on behalf of
Yes.
that. It is on the purpose of appreciating the facts.
Right.
So whether there exist 2 groups of teachers or not. We may not be handling dispute for others, but then that may have a bearing in deciding this.
Now, after this, my lord,
Okay.
this letter, salary was not released. Therefore, the writ petitioner filed a writ petition. And during the pendency, the agreement was reached. Copy of the agreement is my page
The
number
agreement
11.
was reached with Sham Sundar Roy.
Yes, Sham Sundar Roy.
See now this is very very. Now it's just tell which way you will get address. Now you have referred to 2 representations here.
Yes.
By which you are trying to establish that the teachers were not receiving salary.
Yes.
Now Mr. Samsundar Roy was also one of the signatory
Yes.
where he said he was not receiving a salary.
Yes.
Now you enter into a compromise with that person who was not receiving salary.
Now, therefore, let's see the agreement, my lord. Therefore, in the agreement, state is not involved.
Very interesting.
Lordship, therefore, the facts would unfold. Page number 13 onwards.
Please. Probably this court is bit impatient before coming to the end, trying to do the conclusion. Let us see. Let us go proceed with it. Now it makes it curious, Your submission was that by referring to these 2 letters, that even the other teachers were not receiving the salary.
Yes.
Now you had common grievance. You were on the same platform, and then you enter into compromise with a person who was with you on the same platform.
No.
Now that becomes very.
But my lord, Mr. Sundarai is claiming he is not recognizing my appointment. Therefore, there was agreement reached between him. And none of the other teachers or the SMC, including government, raise objection against my appointment, against my recommendation by the
you
SMC.
are going somewhere where this court has not gone till. This the stage of that representation by which all of you claim salary. You say none of us are paid. Your representation plus representation for by 4 teachers.
Yes.
And then you come to a settlement.
Yes, yes.
Now what would be the indication? The non-release of salary was because of existence of some dispute between the teachers.
This agreement is confined to the writ petitioner and the respondent 7, Shamsundar Rai, with regard to my his refusal to recognize me as a science teacher and the pendency of my salary. See the agreement. Agreement will be very clear. Page number 30.
But then by this letter dated 30th July 2016, see Shamsundar Rai also was not receiving salary.
Well, no, whether he receive or other teacher receive or not, that is his claim. SMC will know. Well, and he is the head of the SMC, secretary of the SMC. So the SMC will answer.
It was not a case that all were not receiving salary. You were not receiving salary.
I'm not receiving whether others are not receiving.
This court is finding it now very confusing. You do not know. Your submission also is not addressing upon those issues. No clarity is being attached to this.
No, my submission is, it is very simple.
The projection of the situation till the reference of that representative of 2016, that consequent to your approval of your service in 2014,
yes,
there is a letter written by the authorities
yes,
for addressing the issue of payment of salary. Yes. And then you refer to certain representation by which says that the teachers of all the teachers of the school, they are not getting salary.
No, my lord. I mean,
now next steps comes to a deed of agreement where 2 teachers, those who are not receiving salary, comes to an understanding.
Yes.
Proceed, you see, but then I do not know which way you are trying to project the facts of the case.
My case is, my lord, my case is very simple. My appointment was recommended by the SMC, subsequently approved by the competent authority. Now, only Mr. Sundarai was a thorn on my flesh. Therefore, he continued to recognize my appointment. He became a stumbling block for releasing the salary. That was brought before the authorities, and authority has written
so it means the representation which were filed by them has no bearing in this matter.
But my lord, therefore, this I annex it. I annex it.
You referred it also.
But I refer it. Therefore, my lord, I have to disclose.
Anyway, if you refer it, you just say that it has no bearing.
But I refer it whether they receive or not. But since the copy came to me,
just to project the case that non-receipt of salary was an issue, then you say that yes, kindly see, these are the other teachers also, those who say
yes,
salary has not been received.
Yes, that is the agreement.
So you remain on the same thing.
Right.
Same. You all are at that stage. You all are similarly situated.
No, this paper came through RTI, therefore I disclose everything. It is not that I endorse the correctness of the letter.
This is what? So this will be irrelevant for the purpose
of according to me, it is not that relevant.
But then you referred it. Anyway, you referred it to project before the court that non-receipt of salary was an issue.
Yes. My salary was required. Now, see the content of the agreement, page number 13.
Yes.
This was entered on 28 October 2016. Then I will come to the next page to save lordship time, page number 14.
So this agreement is not required to be gone through.
But in that agreement, my lord, may not gone through, but the relevant one I may point out.
Which para you see?
Para 4 and 5.
That is at page?
Page number 14.
Yes.
With lordship permission, may I read?
There appears to be two agreement, mister. You are referring to the first one, page 13 and 14.
Page 13.
Then 15 also is another agreement.
Yes, sir. Okay. That was undertaking is.
Okay.
Yes. And page 14, para 4 and 5, lordship kindly see.
Yes.
That after resolve all the controversy in between the parties, the first party is the Mr. Sundarai, assured and accept to approve the second party, petitioner as second party as per decision of the mediation committee. So
can we pause for a moment? Yeah. Now, this is an agreement entered into in his individual capacity.
Yes, correct.
Now, whether he agrees or disagrees,
yes,
what bearing it will have on the claim of appointment, legality of the claim of appointment?
It doesn't.
And if at all, you seek implementation of any of the clauses of this agreement, can it be done in a writ court?
No, no, I'm not seeking for enforcement of this agreement.
Okay.
Well,
Yes.
well, page, para 5.
Yes.
It came to reveal that the second party had been doing this regular duty to this school. In this way, the school second party has the right to get the pending salary since 2014. And whenever department will release the area salaries of the school teachers, then the first party will disperse the salary equally to the school second party and other staff as per fixation of the salary, because this pause of science is already a sanctioned pause. In case the first party shall try to turn out or terminate or not to give approval to the said pause, then the first party will be liable and punished in the court of law as per the agreement. Then at last, both the parties have agreed that they will pay all the expenditures of the Sunset Shillong to withdraw the pending cases if required, because they amicably compromised this dispute. So this is the thing, and the next page.
Now this is an just a minute. Two aspects. Are you trying to get benefit of this?
Well, this will I just show that among this individual dispute between the two parties, they reached the understanding in this fashion.
So you are trying to get benefit of this settlement.
My lord, this is one of the.
Go to you.
Yes, my lord.
Now come to the clause 5, which you are reading just now.
Yes.
The last line of that clause 5.
Yes.
In case
yes,
the first party shall try to turn out, terminate, or not to give approval to the said post.
Yes.
Now the question is that prior to this agreement, your appointment stood approved.
Approved already.
Then
approved.
How could this man individually could approve or disapprove your post?
Well, that I understand this particular ending part of the clause
So
is contrary to the government.
We should overlook this.
My lord, it doesn't have any legal effect. But
Okay,
among
so-
themselves, my lord, they reach understanding in this way. Now, page number 15 also,
Now-
deed of compromise.
Perhaps too many questions
No, lordship is
may make you feel uncomfortable.
No, my lord. I invoke the rich jurisdiction, so I have to, my lord, make an effort to clarify. My lord. So
Yes.
page number 15 also, deed of compromise. Condition number 3. May I straight come to condition number
This is
3.
on the same date,
On
executed
the same day. But
By
this
the
is
same
way-
parties.
On the same party.
Okay.
This is the way they understood among themselves.
Okay.
My lord. So that in that connection, a course of action had been arisen between the first
Which one
party.
you are reading?
Condition
Page?
number 3, point number 3. Page
Yes,
15.
okay.
First party and second party for which a complaint case was filed and such, bearing petition numbers and such. Of the High Court note, they mention the writ petition as a complaint case. But this is the way they understand. Shillong, the second party against the then president of the state school, who are the second party, an order was issued to the education department. In this way, the education concern department was replied to give the answer of the Honorable High Court. After that, the science teacher, who are also the second party, had filed an appeal petition to this same Honorable Court for his legal justice. Petition number such, challenged the appointment and approval of the sanctioned teacher by the managing committee, except the approval of the headmaster cum teacher. This is the way to understand, my lord. This has no
Could not get
relevance.
anything. This court could not gather anything from here.
My lord, this is not the way they understand, my lord. Writ petition, they understand as a complaint petition. My
That is
lord,
okay.
well,
But
better, my lord.
then
we ignore it.
that refers to the writ petition which you filed.
Which we filed.
And then they say there is compromise.
But it is compromise. It is compromise.
Now in that writ petition,
Yes.
apart from this man, Shyam Sundar Ray, who are the respondents?
The state respondents. State are the respondents.
But then it was closed on the basis of compromise by two
Between
private
me
parties.
and the Sundarai.
Two private parties.
My lord.
Without
Petition-
anything from the state.
Yes,
now.
yes. The writ petitioner, my lord, believed the integrity, the honesty of the Mr. Sundarai, taking his word, and he came in
It
with
doesn't matter whether writ petition believes or doesn't believe. The question is that the salary has to come from the state.
That is
And what was the version of the state that matters most?
my lord.
It is not that the private person can say release your
Right,
salary.
right. My lord, because the state was ready to release, state was directed to release the salary. Now, in view of this agreement, page number 17, he withdrew the writ petition. He withdrew the writ petition.
Okay.
Page number 17.
Yes.
He had withdrawn. And thereafter, my lord, after this, he has paid the salary for 18 months. And thereafter, my lord, managing committee stopped.
What did you say in your miscellaneous application in that case for miscellaneous application for withdrawal?
Seeking for withdrawal, my lord.
What is that enclosed with the writ petition?
My lord.
It is there.
Yes, withdrawal is there. And thereafter, my lord, the salary was released for a few months and stopped again. Therefore, he filed this representation 2017, page number 18. The writ petitioner has filed the representation. Now may I come to the ending part, page number 19, the last paragraph.
Yes.
That, Madam, in this final paragraph, I beg to state that the headmaster, along with some other teachers, complained against me, in which they claim that science teacher Nusrul Islam, me, has a poor mark in the subject mathematics. So he would not be called a science teacher. In this regard, I want to make it clear that those who have passed the SSLC examination in science stream, he or she is called a science teacher, whether he or she has mathematics or biology as a fourth subject. Mathematics is common in arts, commerce, and science stream, but not mandatory in arts stream. Mathematics is my fourth subject, and many SSLC school science teachers have mathematics their fourth subject. So from the above circumstances, it is clear that the complaint made against me by the headmaster and his supporter is baseless. Moreover, the science particular submitted by the headmaster is confusing one, because he has been possessing the post of headmaster as an arts graduate BA from the foundation of the school. Then how it is possible for the headmaster to acquire the science particulars from other state board where he is constantly regular in his head post duties? Therefore, I would like to request you to kindly look into the matter and include my name in the teacher's sanction list in team's database for such act of kindness. And so he was requested for
that headmaster. By saying headmaster, you mean that Rai?
Mr. Rai. Because internally, he was complaining again that you're not having fourth teacher. You're having a mathematics as a fourth teacher, so you're not deserved to be called as a science teacher. Government has approved already, despite our approval. So he was expressing his grievances and urged the authority to include his name in the sanction list prepared by the government. Now, thereafter, my lord, here another page number 21. He has put up, since the representation was not answered and salary was not sanctioned, he filed this representation, the RDI, seeking information. Number one, particulars of headmaster Sundar Rai and assistant teacher such and such submitted to team database of Narmati School. Proceeding of the SMC with effect 2013 to 17, Xerox copy of the teacher's attendance sheets. So he asked for this information, and the school has given the information. PIO directed the school authority to furnish, and they furnished. And now, the first impugned order I challenge is page number 22, SMC resolution. Page 22. Now, on 2nd March 2017, they adopt a resolution. And point number three, my lord, to discuss regarding the illegal appointment of Mr. Nusrul Islam by the then SMC president. Now, government has given the approval, and now they are discussing my eligibility. And page number 23, Lordship, can you see resolution number 1 and 2? After third-part discussion, it is resolved that the monthly salary of teachers shall remain as government norms. It is also resolved that the appointment of Mr. Nusrul Islam made by the then SMC president beyond the knowledge and consent of the headcom secretary as such on humanitarian ground, and on basis of appeal of Mr. Nusrul Islam, this meeting allow him to render his service as sanctioned teacher temporarily just to gather experience without salary. And resolution number 2 is, this meeting discussed the illegal act of the then SMC president regarding the execution of deed of compromise between the headmaster and Sri Nusrul Islam by passing criminal intimidation towards the headmaster for his vested interest, through which he was appointed Sri Nusrul Islam as service as science teacher, having no mathematics in high school secondary qualification. As such, this meeting felt that the necessity for remain Mr. Nusrul Islam as non-sanctioned teacher, and the same empowered the headmaster to communicate the same to the authority concerned regarding the illegal appointment of Mr. Islam. So this was the resolution they adopted. Because new managing committee came. Now they're alleging that earlier SMC president and the writ petitioner put him under pressure. Admittedly, he did not file any FIR. So this is the thing we challenge. And
the president was that Roy. Is it that Roy? See, that resolution number 3,
yes,
that this meeting was also resolved there.
Yes.
Then SMC president illegally appointed so and so.
Yes.
A science teacher.
Yes.
So this SMC president means that Rai.
No, not Rai. Another person. Mr. Rai was a headmaster cum secretary. Another gentleman was there. His allegation is that I was with the earlier president, and earlier president was instrumental in my illegal appointment. That is his claim.
So what happens to this resolution?
Now, thereafter, my lord, another resolution, my lord, page number 24. On 9 June 2017. Now, resolution number 1, Lordship kindly see. After prolonged discussion regarding the serial number of subject-wise serial number of teachers, it is unanimously resolved that the name of Yasmin is a language is enlisted in serial number census in the list of teachers teams as per the norms of the state and India, hence the list of teachers in census. Now, Mr. Sundar Rai, headmaster mathematics science. Now he's claiming the position of the mathematics and science.
Number 3?
Yes.
Oh, no.
Serial number 1. For the first time, he's claiming the mathematics and science teacher. And page number 25, Lordship kindly see serial number 5.
Now, his status in the managing committee is ex officio member.
Yes, ex officio member.
Then who is the secretary of this managing committee?
My lord, it is not mentioned here. It is not mentioned here, but my information concern, he continued to act as a secretary. And page number 25, serial number 5, Lordship kindly see.
Yes.
Petitioner was reduced to a non-sanctioned post. Serial number 5, Nusrul Islam, assistant teacher. And another impugned order, page number 26. On 22nd
These are all
June.
resolutions.
My lord, 23rd June. Here, resolution number 1, Lordship kindly see.
Yes.
It is resolved that SMC discussed regarding science teacher, Mr. Islam, who were appointed without NCTE norms. Now, Lordship, they are coming to different, relying on different norms, who has no mathematics subject in such a disqualified teacher appointed by the previous SMC president. His completely legal appointment, such after third part discussion, the SMC selected Mr. Sundar Rai, headmaster BA and HS Science, pass as science and mathematics teacher in lieu of Mr. Nuslam. So the SMC requested the authority concerned to accept and allow him as headmaster cum science teacher. So this was the resolution again, behind the back of the petitioner. And another impugned order, page number 28.
See, one thing is that Shamsundar was a BA,
yes,
but then his class 12 was science standards.
My lord, he obtained through NIOS. That is his claim in his affidavit.
But then that is what has been reflected his qualification.
Yes. He was a BA only, and since he was claiming, he came to know that SSC norms only confine 3 sanction posts. Therefore, he was eyeing for the science teacher. Therefore, he obtained a science paper on the NIOS. So perhaps they are relying. That is his contention in his counter.
No, you want to say that he doesn't have a science qualification.
Yes, yes.
So far as the academic.
Yes, yes. That time.
That is a contention raised in the writ petition.
Yes, yes. In the reply also, madam. Now, page number 28.
Yes.
Madam. Another MC resolution, 27 July. Now, I will come to that signature part. Headmaster cum science, joining date. My lord, his joining date 2002. Assuming that he was appointed as a science teacher, 2017 only.
This is serial number 1.
Serial number 1. Now he started claiming that he joined as a science teacher from 2002, before he was appointed. Before he
That
his
is
first
okay, but then
appointment.
how your case will be strengthened by his disqualification? You have to stand on your own qualification
No,
first,
that-
isn't it?
I'll come to that one. I'll come to that one. And another, my lord, the resolution page number 30.
Yes.
Now page number 30, serial number, may I come to the serial number,
How many resolutions are there?
that is how they do. Is how they do.
With the same subject matter covering the same thing.
That is why. That is why. How then is Mr. Rakhal would answer. Page number 31, relevant portion.
Yes.
May I come. It is noted and found that one of the founder and senior-most teacher having the HSLC science qualification. So the school managing committee, school unanimously appointed Mr. Shamsundur Rai, Sansad PA, as headmaster cum science and mathematics teacher in the same school. And the question of additional teacher science does not arise because the government is not accorded any sanction for the additional teacher. But it is worthy to mention in this meeting that the then president, for his selfish gain, appointed Mr. Islam, a science teacher, who has no requisite qualification as per norms, as because he has failed in mathematics in such examination, and also without the knowledge and consent of the headmaster cum secretary, as well as without any advertisement on approval from the authority concerned. Now they are talking about the advertisement. Mr. Samsundurai appointment as a science teacher, so there is no appointment. I'll come later. Mr. Islam did not join the school in due course of time, and the incumbent Mr. Islam, on misleading the then STSO, obtained the approval regarding the opposite appointment order from the authority concerned. So this letter resolution was passed. And on the basis of this, my lord, the government start passing order, page number 32. Page number 32. Now, impugned order, I challenge the second petition, my lord. Page number 32, may I read, my lord? As per resolution number 1 dated 23rd June 2017, adopted by the SMC of the school, declaring Mr. Nuslam as disqualified for holding the post of assistant teacher science and mathematics, since he failed mathematics subject in HSLC examination, and appointment of Mr. Sundar Rai as a headmaster cum science mathematics teacher by adjustment is hereby approved by the undersigned. It is passed by Ms. E.P. Laskar.
Now, when did you appear in higher secondary examination and when did you fail?
That is much prior to the 2014 appointment.
So it's prior to your joining.
Yes.
Now, did you get a job by suppressing those facts?
No, nothing at all. Nothing. That is his claim.
This is, you see, this problem is that is why the norms become very important. It is not that what you say or what they say it is correct. It is the law which will hold the free. Whether a legality can be attached to those resolutions or not, this also would be decided, can be decided only by looking at the norms.
The norms, your lordship permits.
So until and unless, you see, we can understand that you are placing a case of malafide on the part of the other side. Yes, they have adopted different you see, like ways and means to oust yourself from service in order to accommodate resolution number
7.
Yes, but the fact remains, he was in service prior to you.
That is true. Nobody disputes.
And then there is an assertion that he is not only BA, he has a university science qualification. Now, if authorities accept that, the authorities means the authorities, those who are empowered.
Yes.
If they accept it,
yes.
Can you substitute their view?
Oh, my lord, if they have the power to accept, but in due process of law.
Now, if they say that you are a failed candidate,
yes,
and he is a past candidate,
yes,
can you substitute that view in absence of any materials?
According to me, my lord, if they exercise their power, removing me and replacing by him, without fulfilling my due process of law, lordship can intervene. If they replace me in due process of law.
Yes, and another thing, if you can show that the whatever has been observed in this managing committee meeting,
yes,
is totally incorrect.
Exactly.
These are perverse, not based on any materials.
Right.
Okay.
Right.
Now that is what.
Right. Correct.
Okay. Now they say you have mathematics failed. You say no, I am passed. You produce things.
Is a fault.
We can throw out their
Right.
decision.
Right.
Second thing that they say that such and such is university in mathematics. Oh, sorry, in science. You show that no, is in arts. That goes. But then otherwise, which way we can enter into those arenas?
No. Therefore, my lord, the law is very clear. I'll place a decision. Employee can be removed, terminated from service on the ground of appointment in contrary to rules or act. Now, there is a procedure Supreme Court held. Now, if you are to arrive that Mr. Sheng Riso is appointed in contrary to rules or act, you must draw up a proceedings, giving opportunity, gather the requisite materials, and arrive at conclusion.
Provided
Now,
they first find out that you have been appointed in contravention of which provision.
Yes.
Now their show cause notice must say
Yes.
that you have contravened this.
Right. My lord is correct.
So then norms become important.
Right.
Where is the norms?
My lord, therefore, there was no show cause notice. Had they issued me a show cause notice and specifying the ground of my proposed termination, I would have the opportunity to answer. There's no show cause
Now,
notice.
say supposing, let us assume that there is no norms. Is it not sufficient that there was no advertisement? Then we have to go under the general law.
My lord. Then in that case, my lord, they must reflect that the ground of not adhering to advertisement, then that ground must be reflected in impugned order. It is not reflected in the impugned order. Number one. Number two.
Your resolution says that. And that same resolution has been approved.
My lord, that is one thing. And appointment, Mr. Sundarai, he himself, there is no appointment, there is no advertisement.
So that you challenge it.
Therefore, I challenge.
You filed representation saying that his appointment is also without advertisement.
Therefore, I challenge the secondary petition.
See,
it is there. His appointment, I challenge in the secondary petition.
Now, the appointment related things, especially the observance of the normal formalities of appointment.
Yes.
Like it became very important after Umadevi's case. Irregular, illegal appointment.
Yes.
Right. Now the law says that any appointment made without valid advertisement.
Yes.
And without allowing the other eligible person to take part.
Yes.
Without holding a selection process is illegal.
Yes.
That is what. Earlier system was something different. 92 Parashing. The normal assumption was that somebody continued in certain post for 2 years.
Yes, regularization. Yes.
This continued till 2006 until this Umadevi's judgment.
Yes.
Now thereafter became this appointment thing very nice. And Umadevi's judgment came just to stop this backdoor appointment. That you are my favorite, I take you to service. The other person is Mr. Devna's favorite, he takes into his service.
Right.
So
correct.
To stop this.
Right.
Now here, your matter also,
right.
It seems like a matter of favoritism. Like this is apparent, but then the court cannot hold it. Court has to decide it on the basis of the law. That is what the problem is. Right. Now, this is where
page 32.
You have. They say that you are not qualified.
Yes, the ground is mathematics.
No, yes.
I failed in mathematics.
Yes.
No, I have given my. I also my.
Because science teacher means a teacher of mathematics also.
Yes.
So you failed in mathematics.
Now mathematics.
Now, you say you have not failed.
Yes.
Or if you say it will failed, you want to say that the norms must say that.
There is no such norms that prohibit the petitioner.
That is very unusual. Right from the beginning, this court has observed that without any norms, how a person can be taken into service. It's very, very difficult to comprehend that. You see, like any public appointment will be done. For a science sport,
yes,
you will recruit a Sanskrit graduate. That's the case here. You say, response number 7 is a arts student. Now he becomes a teacher of science. No norms, that means it is allowed. Once it is approved, it is allowed. Approval gives the seal of legality.
Correct.
Can it be?
Now, this is the ground they have mentioned. I'll show my
Okay,
the
then
mathematics.
it's all right. Then proceed.
And now they refer to SMC resolution 23rd June. And that is available in page number 26 of the compilation, which Lordship has gone through with me. Page number 26.
Yes. NCT norms.
Yes, 23rd June.
Now,
So relying on this,
what is
joint
the
PMC.
NCT norms? What is the NCT norms? What is NCT?
My lord, NCT, my lord, this NCTE.
Full form of NCT?
NCTE, my lord, just.
This NCT norms is enclosed in your petition.
No, my lord, it is not there.
You have not put an effort to procure that also.
It is
so
not
whether to satisfy yourself to whether NCT norms will apply to appointment under the service scheme or not.
But because
you
they
did not even bother to verify it.
My lord, the impugned order, they don't refer to NCT norms.
Now, what is that NCT? What is that NCT norm?
My lord, that is a national National Council. Yes,
Education.
Teacher education.
Okay. National Council for Teacher Education. What does it say? Where it
My lord,
applies?
that annexure, I'll come, my lord. That annexure, but we have annexed, my lord.
Who has laid down these norms? By central government.
By central government.
That is by the
NCTE.
notification of the Education Department.
Yes, NCT laid down the norm.
Is it something a rule or not executive instruction?
My lord, that is a rule was framed under the Right to Education Act. NCTE is a council, is an autonomous body empowered by the central government to lay down the norms for the appointment of a prime
Under the RT.
Yes, under the RT. I have a next subsequent page I'll come
So these are instructions by NCT.
It is there, the rule
And
is
these
there.
NCT instructions will not apply to post under the services of vision.
My lord, it is a private school. My lord, it is not.
Scheme is under the central government. And if you say it is a private dispute, then your writ petition is not maintained.
My lord, in that case, if NCT norm is applied, both of us are not qualified. So I will also go. His appointment also will
It's
go.
all right. But then, so long there is no adverse order passed against him, he is not coming before this court. Now you have to stand on your own.
Therefore, my lord, I challenge his appointment.
Just because other side does not have qualification will not make yourself qualified.
No, but that is true. Yet I not challenge his appointment. My lord, that is true. But I also challenge his appointment.
So, what is your contention? NCT norms will not be applicable in this.
Well, he has taken
this is your contention that NCT norms will not be applicable.
Yes.
This is a private school.
My lord, it is a temporary appointment. It is a private recognized school under the SSC scheme. Now,
your submission is something you see. If you say this is a private school and then NCT norms did not regard these things, then the approval or no approval also will not have any bearing so far as case is concerned. You cannot adopt two stands.
No, my lord, therefore, from the beginning.
In such a case, we will say, then in such a case, what the managing committee say, that will have the finality.
Therefore, from the beginning.
For the permanent teachers, Lordship, it will be applicable, Lordship. For the temporary appointments, it may not be applicable.
That is okay. We'll see.
Sanction post.
You see two things. The contention that is a private school managed by the managing committee. Then in such a case, the state role will not come. If it is not under NCT. But then you have to give us clarity about that, whether these NCT norms will be applicable to the recruitment under the SSC scheme. Because Mr. Sangresh's submission is now, you see, like for some certain things, approval will have a bearing, then again certain things is private. Now this we cannot, something seems like it's like very tough to accept, you see. So that is what this court is confused.
Now in that impugned order, they refer this MC resolution.
Yes.
Now,
so
it has two.
We can
disqualify me. Number two, the appointment Mr. Sundarai was approved by the authority. Now, admittedly, my lord, before my disqualification, it is the SMC or the approving authority did not also issue any show cause notice to him. And next page number 33. 33. Another impugned order. Appointment of Mr. Sundarai. So page number 32, his appointment was approved. Another one, different date, Lordship, kindly see.
Page 33.
33. As per resolution dated 27 July 2017 of the SMC resolution, the appointment as per senior basis follow. Sundar Rai, HHSC Science and PA pass as headmaster cum science and mathematics teacher. His training is 17 January 2002. 2002, he was not yet even appointed there. Now, all the teachers are hereby approved provisionally by the undersigned. Same authority to approver.
State has filed any affidavit in this matter.
Madam?
State has filed affidavit.
They filed affidavit. They have annexed in the affidavit. They did not give me a copy. I came to know through the affidavit. So I annex now. So page 32 also, his approver, Sundarai approver, on 27 June 2017. And 4th October 2017 also.
This is very confusing, you see. Now, this approval of somebody who appointed in 2002,
that is,
it's been done in 2017.
Yes, right. Is how they
you know, it's as if, see, like there is nothing. Forget about existence of any written law. You just act the way you like. One officer will come, he likes certain work to be done in one way, he will do it, and the other officer will do it in different way.
Lordship, in this matter, Lordship, the appointment of the petitioner, Lordship, it was initially approved, provisionally approved, Lordship, in view of the absence of a mathematics teacher. And subsequently, Lordship, it was cancelled. Because this petitioner, Lordship, he is not a mathematics qualified teacher.
So are you disputing that mathematics qualified teacher or not?
No, it is not required.
Huh?
It is not required. Well, it is
but then the fact remains that you do not have qualification in mathematics.
Mathematics.
Whether it is required or not.
No, my lord, mathematics, my lord. Class 12 exam, class 11, 12. Mathematics was one of my fourth subject. I passed out all. I succeeded in the class 11, 12. Now, only the ground is that mathematics was as a fourth subject. Therefore, it should not be considered as a pass.
But they say you have failed in mathematics. Forget about whether fourth subject or the main subject.
It is not a fail. It is not a fail. I'll show my mark sheet later, my lord, with lordship permission. Now, this page number 33. Provisional approval. My friend Kharmi said that my approval was provisional. Mr. Sundarai was a provisional. And so he got two approval.
See, it's okay. I do not know why you are trying to draw advantage by drawing easy comparison with Chandralal. See, just for the time being, forget about this. You just establish your qualification.
Yes,
then you come and disclose him.
Right.
Now, you see, like, if you say that your approval was provisional, as such and such approval was also provisional, this will not carry advantage to your case. Now, provisional approval, he says the reason for cancellation of that is that you do not have qualification in mathematics. Now, the other side's thing provisional, but then maybe they have found him suitable. They have a certain discretion, isn't it?
They have discretion, but they have to exercise their discretion in accordance with.
So long they do not exercise it arbitrarily,
yes,
there is no question of challenging it. Now, challenging that comes, but then just because the other side also were similarly situated so far as the approval is concerned, will not add any advantage to your case.
Well, they have the discretion, but that discretion should be.
Now, only thing is that if primarily if it is reflected before the court, the reason for your termination is that you do not have qualification, then it is your duty to establish that you have qualification.
Yes. My lord.
And then you see reference to all those agreements and all those things definitely would not carry advantage to any side.
I'll show my mark sheets. I have an
No, mark sheet. Why to show a mark sheet? You have to say that the reasoning given is not correct, isn't it?
Yes, we have replied.
And then they have come to a finding that you do not hold a qualification without issuing any notice to you, asking you to prove your qualification.
Right.
So that is a principle violation of principle of natural
justice. I'll come to that.
I think if you confine your argument to all those things,
yes, it will come down to that issue.
Okay, then your approval also remains. All also remains.
Yes.
Now, second thing is that the application of that NCT.
My lord, I'll come to that.
Now, that is where. Yes. Prima facie, if you come to page 32, which we were reading just now.
Yes.
That is based on the resolution of 23rd.
Yes.
And as you have shown us.
Yes.
That is that reason is for non-fulfillment of
mathematics.
requirement under NCT norms. Now, show us that NCT norms is not applicable. Or if you say it is not applicable, then we'll ask them how it is applicable to show.
Well, well. Now,
Lordship, page 23 is the approval of the appointment of Shamsundar Rai.
yes, yes.
Yeah.
Approved.
Right.
Yes.
This approved on the basis of the resolution.
Not a provisional approval.
No, not provisional approval.
Okay. So Mr. Sangreshu is not correct there.
Page 23.
Of this compilation.
No, of this of my affidavit, Lordship.
Wait, which date?
So this document is not part of this compilation.
No.
Wait, which?
Have you received a copy of the compilation signed by Mr. Kharmi? Have you received copy of the compilation?
We have furnished
I have just received it.
Please, if you refer from there, then it will be easier for us.
In my affidavit also is
It is
there.
there,
Page 23. In my affidavit.
If you are
It is
referring
there,
to on the
my
compilation,
friend is
that will
referring
help us.
to.
Okay, yes. 27.
27. Well, referring to page number 32 of the compilation. My friend is referring to the page number 32. The same.
Compilation.
Yes, of the compilation.
Yes.
It is the same.
Yes, Lord.
It is the same.
But then that is later.
As per resolution 2360.
My lord, this was the first
23.6.
approval, and second provisional approval comes,
Order.
page number 33. Now this approval on 27 June 2017, approval of Mr. Sundarai.
Now,
And 33?
This is, see, entire thing is so confusing, so confusing. How can in 2017 an approval be accorded to somebody who was appointed in 2002?
That's right.
These are all post facto approval.
Well,
Achha, anyway, then what happens?
then
yes.
page number, this 33,
Yes.
they are referring to resolution 27 July 2017.
Yes.
That is available in page number 28 of the compilation.
Yes.
Yes, compilation.
Then this is going to school.
28. His approval by backdated
27/7/2017.
Yes.
What is that resolution? Where is that resolution?
resolution, page number 28 of the compilation.
Okay, 28 of the compilation.
Yes.
The appointment as per seniority basis. No, very fun. See, this fellow has been again provisionally approved.
Provision.
Now the first letter 32 says
Yes.
that Shamsundar Ray
Is approved by the
is
undersigned.
approved.
Is a final
Now,
approval.
as per this order, all the teachers are hereby approved provisionally.
Provisionally.
And number one is his name.
Yes. So for him to approval
What is this, Mr. Kharmi?
by the same authority,
How you will explain this?
page number 32 and 33.
See page 32 and page 33. And the signatory is the same person.
Same person, same person.
Is 27 June 2017. 11:10. The resolution.
Very difficult. These are the cases where some enquiry should be ordered. It's not possible for this court to determine the purposes behind passing of so many orders, adoption on so many resolutions.
This order, Lordship, it was passed on the basis of this resolution passed by the managing
Just
committee.
satisfy on two aspects. The first letter says, as you pointed out just now,
Yes, Lordship.
to counter Mr. Sangreshu's submission, this appointment of Mr. Sundar Rai was approved.
Approved.
Come to the second letter, 33.
Yes. I have
All the
here.
teachers are hereby approved provisionally.
I hereby approve provisionally.
So then, this is a degradation of approval. What is correct there? It seems you have two different stands.
This order, it was issued on the basis of the resolution.
Whatever can be, when a person's service stands approved, where is the question of provisionally approving it again? Is this officer still there in the service?
This officer, I'm not sure, Lordship.
I think some matters we will be asking for personal affidavit from some people. Because you see, this
Out
mess
of
would
record,
not
other
have
cases
been
also I came
created.
across this officer.
This mess would not have been created if the managing committee, oh sorry, if the government was strict in applying rules.
Right.
Now it happens that the officers behave like this, and the managing committees that take advantage, or maybe there is a connect between them. This is the indication.
Resolution, Lordship, it does not say to approve the teachers provisionally.
Are you bound by the resolution of the managing committee? Can they bind you? Are you not supposed to act as per law?
Yes.
Give us the norms. You place us the norms. You place us the norms before these things. What is the norms of appointment of the teachers under this scheme?
Yes.
You place it before us. We'll see it.
Lordship, when the school
And if there is no written norms, then you file an affidavit showing the norms which you
the
have.
advertisement has to be issued, Lordship. That is the thing.
Then why did you, if that be the thing, then why did we provisionally approve? You said that he was not having qualification, that was provisionally approved.
Because, Lordship, when the school is brought under SSA, the new managing committee is constituted, and thereafter the teachers are appointed on the.
So when this school was brought under SSA, which year?
This school. Huh? He's for the managing committee.
No. Then you just tell us when you have brought this school under the under the scheme. Which year?
In 2002, Your Lordship.
Where is that order?
It is in my affidavit, Your Lordship.
That has not been appended in this thing.
No. In annexure R5, I have given.
This code, you see, like it was hard for such time, but then even now, the confusion is full of confusion.
Respondent of 5 affidavit, Your Lordship, in 248. Annexure 5.
Affidavit filed by resolution number 5.
In 248.
Huh?
In the application of 248 2018.
Seconded petition.
Read petition.
Item number 4.
How many read petitions are there?
First read
There is 2 read petitions. One is for salary and another is for termination.
Item 24.
Right now we are dealing which one? 248 is what?
First read petition.
First repetition, item 3.
Is salary?
First read petition for salary.
And then you are referring to which read petition now?
Your Lordship, this I am referring this one in
The second
First read petition, second read petition.
So tell us the read
Second-
petition number.
second
Tell us the read petition number.
248.
248 is you are holding 248. This is a mess. It seems like you see.
He's
Even in
referring to
spite of-
seconded petition. Seconded petition he filed. Affidavit by respondent number 5 in seconded petition 473.
248, actually. This is the affidavit filed in petition 248 2018. The first petition.
Affidavit filed by whom?
By the
By
respondent
respondent
number
5.
In 247. Read petition number 248.
248.
248 he did not file. Number
That's
5 did
number
not
five.
file affidavit.
I filed this one. I have given this one.
An affidavit you filed on 24/4/2023.
Yes, Your Lordship.
Mr. Sangresho, it seems you are not
The copy is
not been informed about the filing of this, and without the affidavit you are arguing a case. Unnecessary making things bulky, I do not know.
I'm sorry,
And
but
this
it
root
is-
cause is the government.
it is there. 248.
See, this court was repeatedly putting you a question when it was brought in, which were brought in. Now, Mr. Devnath says that it was brought in under this scheme on such and such.
Page 30. Page 32.
Page, what page of your affidavit, Mr.
32. Page 32.
32. Is not true. It is you have not given typed copy. Why registry has taken into consideration this thing? Should not be.
Your Lordship, it may be my copy was, but after long time, it become just.
You should have typed then it was.
Your Lordship, some other pages also come up. It is not totally readable.
This is opening permission then?
My lord, this has nothing to do with the NCT. It's opening permission only.
Your
You
Lordship,
do not understand. See, the question is that when this school was brought under the Sarva Shiksha Abhiyan scheme.
NCT.
No problem. This school opening permission is given. Showing. When this scheme was made applicable.
just a minute, Your Lordship. Your Lordship, then let me record this in 248, affidavit filed by the respondent number 7. When this NCT norm is improved.
When this school was brought under the Sarva Shiksha Abhiyan, first you say it. Then we will decide the applicability of these sensitive norms. Mr. Sangrai, so
This one is in my compilation. He is referring to page number 18 of his affidavit.
yes,
I have the next day in the compilation. I'll come to that one. That is page number 38 of my compilation.
page number
38, 38.
38.
Yes.
What does it say?
My lord, this is the
Yes.
recruitment for appointment of teacher as per NCTE. Now it says recruitment. As you are aware that NCTE norms came into effect from 23rd August 2010, where it has been specified that
That makes it clear. Then NCT norms is applicable.
yes, from 2010.
Yes. Your appointment is after 2010.
Yes.
So what is the norms? What is the requirement under the NCT things?
Now, Lordship, kindly come down.
Yes, it has been
This
written provided,
application to all category of schools, whether it is government, private, aided or unaided schools.
Yes.
Now, in this connection, you are requested to issue instruction to all non-government schools to recommend only those teachers who fulfill the NCTE norms in the qualification.
Yes.
Following are the qualification norm prescribed by the NCTE. Primary school, HSLC pass 45 marks in diploma in education talent.
Yes.
Now, for upper primary, PA or PAC pass and B.Ed or B.Ed special education.
Yes.
Now, if a person is appointed for science, he must be a PAC. If he is appointed for arts subject, he must be PA.
Yes, that is implied.
Yeah,
That is
implied. Implied.
Even primary also, HSLC passed with 45% will win that trigger to particular
Yes,
subject.
yes. And immediately, Mr. Sundarai also did not have a PAC.
It's all right. So
Now-
just talk about ours. We'll see Sundarlal.
Yes. And the next page,
Yes.
39.
Yes.
The next page is a continuation, some modification. Now, this is in continuation of this office letter dated 28 March 2013 relating to renewal of contract appointment.
Yes.
In this connection, I am to request you to kindly consider renewal of all those contract appointees of 2012, both set pass and non-set pass. However, in case of fresh candidate, preference be given to those having 45% in HSLC.
But then you do not have a contractual appointment here.
Yes.
Your case is not a case of contractual appointment, isn't it? Your case is not a case of contractual appointment, so far as your claim is concerned. So we have nothing to do with that one. Renewal of contractual appointment.
It is not renewal.
So that is not covering. That is not coming to your case. This may not have any relevance so far as your case is concerned.
Yes,
Your case is
yes.
simple. Your case is a case of termination.
Termination.
On the ground of not having qualification as per NCT.
Yes. So that
So
is
let
one
us
of
see. Let us see whether you have or not. What is the
now NCT norms. Shall I come? Page number 40 is the
you have
NCT.
read, showed us just now 30 page 38
This is the instruction issued by the state government.
Yes.
Now NCT norms is available from page 40 onwards.
Page
40. 40.
Yes.
Now notification dated 23rd August 2010. In exercise of powers conferred by subsection 1 of section 23 of the Right to Children Free and Compulsory Education 2009, and in pursuance to notification dated census 2010, issued by the Department of School Education Literacy Ministry of HRT, Government of India, the National Council for Teachers Education NCTE hereby lays down the following minimum qualifications for a person to be eligible for appointment as a teacher in class 1 to 8 in school referred to in clause such of the Right to census 2009 with effect from the following this notification. Now we are not concerned with the class 1 and 5. We are concerned with the next page, page number 41. So it is a school concern here is the upper primary school. Now, class 6 to 8, Lordship got it. Page number 41.
Page 41.
Yes.
Class 6 to 8.
Yes. Now, qualification number 1 is BA/BSc and second year diploma, 2-year diploma in elementary education.
Yes.
None of us are having this. Or BA/BSc with at least 50 marks and 1-year bachelor B.Ed. None of us has. Or BA/BSc with at least 45 marks and 1-year bachelor B.Ed in accordance with NCT norms. None of us has. Or senior secondary or equivalents with at least 50 marks and 4-year bachelor elementary education. None of us has that qualification. Or senior secondary or equivalent with at least 50 marks and 4-year BSc BSc education or BSc or BA education. None of us has. Or BA/BSc with at least 50 marks and 1-year B.Ed, special education. None of us. And pass in teacher eligibility test to be conducted by the appropriate government in accordance with the guidelines framed by the NCT for the purpose. So these are norms laid down by the NCT.
Your school is of what standard? Is it a primary school or?
It's a upper primary school.
Upper primary school.
It's a private school, but recognized.
Classes from?
Yes.
Classes from?
Well, the class 6 to 8.
You have class 6 to 8.
Class 6 to 8 is upper primary school.
Upper primary school.
Yes.
There is no primary section.
There is no primary
so
section.
This is what will be applicable to you.
Yes.
There is no dispute about this.
But this is the norms.
That is, this is not disputed by the others.
Yeah.
Okay.
And now the Mr. Sundarai.
So now, if you say that none of you have,
yes,
then your claim goes.
My claim also goes. In that case, his claim also goes.
But then will this court will?
But I challenge his appointment.
Let the state take action for that.
Therefore, I challenge his appointment.
You cannot, so far as you are concerned, you will not get any relief from this.
No.
Admittedly.
My lord, suppose I may fail. And when I challenge his appointment should also go. That is my
challenge to his appointment.
I challenge his appointment.
What is the ground of this thing?
I challenge his appointment, saying that in his case also there is no advertisement. In his case also there is no NCT norms. So to me, he said, I do not have a advertisement, no NCT norms, so my appointment is wrong. He cannot say his appointment is right. So therefore I challenge. So in that event, both appointment will go.
No, if that happens, that event you do not have to refer to all those lengthy facts which you have referred to. It's not needed.
No.
All those parts, the development. You see, this even for determining the malafide on the part of the as well as by you or the respondents. Not if admittedly you do not have the qualification, you go. Okay. At the same time, you say that you have put a challenge to them.
Yes.
Their thing. Can you do it? If you do not have locus by yourself?
My lord, because if I have a fresh entry, I cannot question others' appointment. But I was already in service, I was removed, and he was replaced. So I have a right to question his eligibility, his appointment. You cannot go
State what you
singularly.
will say about the qualification of the respondent number 7?
Same thing. So therefore, my contention is
What is your basis for approval his appointment?
His qualification, Lordship, is HSSLC Science.
Are you in dispute with qualification, set of qualification which is prescribed, as has been shown by the senior counsel just now?
We are not
You are not
disputing
disputing.
this,
Now, do you want to
qualification.
say this respondent number 7 fulfills this?
This private respondent also, he does not fulfill this.
So then how come? Then he also will go. Will interfere with both the appointments. Yes, Mr. Devnath, what you will say about this?
Your Lordship, here, his compilation, page 40, Your Lordship.
Page 40 of the compilation, yes. Yes.
This is the notification is coming to effect on
23rd
23rd August 2010. So my appointment was there in 2002. And in this page 42, you will see paragraph 4.
Page 42.
Page 42.
Yes.
Teachers appointed before the date of this notification.
Yes.
The following category of teachers appointed for the class 1 to 8 prior to date of notification need not require the minimum qualification specified in para 1 above.
So you come under this. You are covered
I
by
come
this.
under this.
Yes.
And my school is brought under the SSA in 2010.
So Mr.
This
Sangreshu, now matter is confined to very minimum thing. He is saved by this clause. Now it goes admittedly that you do not have the qualification, and he is served by operation of this clause 4.
Page number 42, Lordship is referring to. Page 42.
Page 42. Teacher appointed before C clause 4.
Yes. The following categories of teachers appointed for class 1 to 8 prior to date of this notification did not acquire the minimum qualification specified in para 1 above. No? Para 1 above.
So one thing is sure that he came into service in 2002, and the approval was on the basis of the seniority.
No, my lord, he was appointed.
May it be provisional or
his
not
appointment.
provisional.
No,
Now, in view of the fact that you do not have qualification, we cannot challenge it.
But his appointment as a science teacher is 2017 only. His appointment as a science teacher is 2017 only.
No, it is an approval, you see. But the fact remains that he was appointed.
No, he was appointed earlier without science qualification. That is admitted fact. His own affidavit says, his own education qualification says.
When he has acquired that qualification?
Yes, that I may refer to his affidavit.
No, but then this is clause 4 makes an exemption for them.
No.
So whether he acquires it subsequently or not does not matter.
No. Well,
see, if this code 4 is made operational, whether he has science qualification or not, that also will not matter.
My lord, if he was appointed for science prior to arrival of this NCC notification, then clause 4 will come into
NCT
operation.
notification came in 2010.
Yes.
When the Sarva Shiksha Abhiyan came. When the Sarva Shiksha Abhiyan.
My lord, this would be SSA would be, my lord, after the RTE Act only. SSA was born under the RTE.
When that SSS scheme came, it was made applicable.
But this was started from, my lord, maybe perhaps 2013.
No, we need a definite reply.
That one I will, my lord, I would ascertain. But with regard to Mr.
Then matter will be cut short. You do not have to go for lengthy determination of the things. If it comes to qualification, if qualification remains the main issue, then that will be done these things. And whether this NCT norms application We'll just see. If a person is taken under the service scheme prior to 2010, this is okay. But then this is not a case that he was made a fresh appointee.
But his case is also a case of fresh appointment. May I show his affidavit? It is very clear. He admitted that he was only PA qualification, and he obtained only NIOS through NIOS in 2014-15, and appointed in 2017 only.
That is okay, but then he was in the service from prior to 2010.
Well,
when this notification came into this.
My contention would be, had he appointed initially for science post without fulfilling the NCT norms, then clause 4 comes into play in his favor. But he was appointed for different posts, for graduate, for social science, perhaps, and he cannot claim that I was born in the science subject in 2002. That cannot be.
No, it doesn't say anything about the shifting of the department or the subject. Nothing. It's simply, it's a very simple and
Now,
says like.
I may take his affidavit, one affidavit, then be very clear.
If it says that
Now,
the prior date of this that need not acquire the minimum qualification. Now, definitely this will be given effect by the authority concerned.
May I just come to his, the affidavit by the government. Affidavit filed by the joint DMC. My Lordship got the affidavit filed by respondent number 4 in the first WBC.
248.
248.
Respondent number? Respondent
Respondent number 4.
4.
Yes.
Is dated 13 to 2018.
Yes, this affidavit was filed.
The problem, you see, there is an affidavit filed.
December.
This is affidavit filed by respondent number 1, 2, 3, and 4. Then again affidavit filed on behalf of respondent number 4.
4 separately, he filed again.
So you are referring to that separate one?
No, separate one.
I do not know what is happening.
The respondent has filed in that way. They should include the number 4 in the first count affidavit. May I take para 9 of that affidavit?
Who is respondent number 4? Is the?
4 is the Ila Begum, the joint DMC, the one who issued 234 impugned order. Same officer.
Yes. Para 9, what is
Para 9, it says, my lord, with regard to the government statement made in Para 23 and such petition, the answering deponent back to state herein that original appointment of Mr. Sundar Roy as headmaster with 3 sanctioned posts of teacher norms was duly approved on 1st September 2010.
Yes.
Following the appointment of the teachers when the school was taken over by the government under the SSA in 2010.
Yes.
Now it is reflected 2010.
That is all right.
Now
you want to say that this is after the notification.
Exactly.
You don't want to contain. But then the fact remains that he was in the school only.
That
the
is
original
true.
appointment. So original appointment was before that.
Appointment, yes.
That is what. So that doesn't make out any case for you.
No. Lordship,
rather helps their case.
No, Lordship, can you see then? Come to the next page. Para 7. May I continue? It's a lengthy.
This is para 9. We are on para 9.
We are referring. Yes.
Page 7.
Page 7.
Yes.
May I continue? It may be mentioned herein that there was no strict provision for language, science, Hindi, social studies subject to teachers at that time. But subsequently, the government introduced a system of 1 teacher each for the subject of science, social studies sometime in the year 2010-11 onward. Accordingly, 3 teachers, namely, continue to serve in the school, adjusting the headmaster Sundarai as language teacher. He was adjusted for language teacher also. Hemadur Rahman as a science teacher and Sansan as a social studies. It may be further be mentioned herein that from the inquiry report referred to above, in addition to the above 3 teachers, there are 2 more non-sanctioned teachers, namely Apu, Bhaskar Siddiqui, and Sansat, appointed by the SMC, but with a resignation tender by Mr. Rahman, it was decided amongst the teachers themselves to restrict the number of teachers to 4, including that of 4 teachers, and to accommodate the teacher headmaster in the said vacant post on the requirement of requisite qualification under NIOS. NIOS, and accordingly, Sam Sundar Rai, headmaster, came to be adjusted in the post of teacher of science and mathematics. Now I'll come to his qualification. Qualification he has.
Do you want to contend that he doesn't have BA also?
Madam?
He is not a BA pass also. You do you know what to say?
Originally he was a BA.
That is enough. Good enough.
He was a BA.
That is good enough.
But it is a different subject.
One thing remains sure that he came into service before 2010. So in such a case, that minimum qualification which is prescribed in that notification will not be applicable to him. But then your service came in 2014.
2014.
So that means then you have to fulfill this thing. The moment if it is shown that you are not.
My humble submission is, my lord, the appointment as a headmaster with the qualification of BA is definitely different from the science teacher. Now, his appointment as science teacher is 2017 only. Now, may I take his qualification?
Now your initial stand that NCT norms will not be applicable.
Yes.
That is what was there. So now, does it remain or not?
Yes, yes. But therefore, my first contention is
this code
NCT
right
norms.
From the beginning, there is difficulty in catching the what is the like the main contention.
No.
Now the submission started in one way. It proceeded in one direction, and admittedly, it is because of the fact that none of the parties were aware about the application of norms at the beginning of the argument of this case. Now, what needs to be taken care of is that you take a solid stand whether NCT will be applicable or not applicable. If it is not applicable, then you should say that it is not applicable.
Yes, my contention is that NCT norm is not applicable.
To the appointment?
To appointment under the SSS scheme.
Under the SSS?
Yes, yes. That is the contention. In my reply also we made.
This is one contention. Then?
And other contention is, my lord, the procedure for removing my service is in violation of the principle of natural justice. No show cause notice was issued to the petitioner. And third would be, even assuming that my NCT norms is available, applicable, Mr. Sundarai and both are not eligible, not qualified, not possess that requisite qualification. Because he obtained science in after 2010 under NIOS. And that mark sheet, I'll just place it in.
Mark sheet is a part of writ petition.
Mark sheet, yes. I'll come to my.
Whose mark sheet? Your mark sheet. Do you want to show that you are qualified under the NCT?
No. I'm not saying that I qualify under the NCT. I'm saying that I admit that I'm not under the qualified under the NCT. Now, may I just show his qualification? Then I'll come to my side, my qualification also.
Now, if it
now,
means if yourself is not qualification, if you do not have qualification, what locus standi you will have to challenge to his seat.
Now, therefore, I say that NCT norm is not applicable under the SSA. Therefore, I challenge. And now, Mr. Sundarai paper also, Roshim, kindly see, come to the additional affidavit filed by number 7, that Mr. Sundarai.
One second, Mr. Can you maintain both the stand? that NCT is not applicable, at the same time that he is also not qualified in the NCT.
Yes. No.
Can you maintain both the stand together?
Oh, my lord, this is alternative submission, my lord. My primary contention is that NCT norm is not applicable for teachers appointed under the SSS scheme. Alternatively, since he racked up that issue of norms of NCT, therefore this is my reply, that NCT norm is not applicable, and even assuming it is applicable, he is also not fulfilled in that case. And so far as the advertisement is concerned, for him also there is no advertisement. And now his mark sheet, Lordship, kindly come to page number 21 of his additional affidavit.
One second. Yes, Mr. Please, yeah.
My lord, additional affidavit by respondent number 7 on 20 April 2021. Page number 21. His mark sheet.
Just. Respondent number 7.
7, well. My lord, the reason why I urge my lord vehemently
One second.
to persuade my lord here is, though the boss is...
Just hold on for a moment. Yes, just a minute. Let us come to that thing. We are holding a huge bunch of affidavit.
Yes.
So, not that easy like you to find out. Yes.
The pleadings are correct.
You are referring to?
Page number 21 of the affidavit. Page 21.
Yes.
Now, this is his secondary school certificates.
Page
number 21 of the affidavit.
11. Seems something
Higher
different.
secondary.
You're holding a wrong affidavit. So many paginations is a problem. We do not know what is correct, what is not.
First, may I start from page number 9, his entire qualification.
Everything has become mess.
He has Alexis degree certificate also.
Page 21.
Page 21. Lordship got it.
Till now I have not got it. It's page 21 here it's different. It's 19 and 20 is complaint. And then
well, not the
21 is the second page of it.
The additional affidavit. He has filed 2 affidavit. Additional affidavit.
We'll come back after the break, Mr.
My lord, this item number 9, my lord. As per the last order, my lord, the respondent number 2 was allowed to file affidavit. My lord. It was filed just today. I have received it. And more so, my lord, the petitioner is yet to take steps on respondent number 3.
My lord. Taken.
But I'm not aware of it.
Item number 9.
9.
Nine, lordship.
So it has come up in the hearing list without service, completion
That's
of
why, ma'am.
service.
And even
Normally it doesn't happen here in
yes,
this court.
respondent 2 has filed the affidavit just today, my lord.
Now that is all right. See, you can understand. We will give you time.
Respondent
That
number
is all
3 is yet to, my lord.
right. Anyway, you are appearing for the
For petitioner, my lord.
and who is responding about that?
Respondent number 2.
So I filed only today,
My
No,
lord.
I have received, my lord,
before.
on the last occasion.
I received today.
Still, I received today, my lord.
When do you want it?
After a week, my lord.
After yes, Mr. R. Gurung, learning GA. Submits.
Is there any report, my lord, in respect to respondent 3 has
Respondent number
arrived?
3.
Report in respect to respondent number 3, my lord, has arrived. Report.
That we don't know, my lord. He has not filed the affidavit to service also.
Then we have to check the case. We'll do it in the second term. You have verified it.
My lord,
Yes.
my friend is there, and other parties, respondent number 2 was allowed to file one affidavit. That was filed today. I received the copy just now. That is the position.
Can you help this file?
सर इसको कंफर्म करो सर जो है टेस्ट टिकट तो आई Number 7, my lord.
Item number 7.
Yes, lordship.
Yes.
My lord, here, on the last occasion, if my lord can see the order dated 7/5/2024, here, my lord, what had happened, inadvertently, my lord, wrong case number has been mentioned, my lord. It is supposed to be 203. It has been mentioned as 202, my lord. My apology, my lord. It is supposed to be 203, my lord.
It's all right, but then have you received copy?
My lord, we are yet to receive. Here, what has happened, the learned trial court, my lord, that was the first day when we appeared. In fact, my lord, here the court has called for the IO seeking certain instructions, my lord. Copies has not been served on us, my lord.
Okay, Mr. S. Panthi, Learned Counsel, let me know the petitioner submits that the petitioner is yet to receive a copy of the charge sheet filed in Sadar PS case number 203.
No, sir, Sadar PS case number is, my lord.
Here it is
Yes,
202.
my lord. 203. 203, my lord.
It should be 203. Are you sure?
Yes, yes, my lord. I'm sure.
203 of 2022. Then where from you got this 202?
No, my lord, 202, actually there was a case in counter case, my lord. Case in counter case. So 202 is the case, my lord, filed by us. The petitioner, my lord. Lordship.
What is it? 203 within 08. 203 2022.
Yes, lordship. Now this has been, my lord, culminated into GR case number 554. That is already there on record, my lord. 54 S23, my lord.
So then it is otherwise there.
Yes, lordship. It is there.
Within bracket, within that GR case number 54 S of 2023. 54 within bracket S. This is small s. 23. Rest of the things are all right. Only
Yes,
this,
yes,
only the case number is.
Yes, my lord.
Just how it went. Just.
Even the sections, my lord. Sections.
Okay. Stop. Listen. The Lorder Council also points out to the order dated 7/5/2024, wherein the above case has been wrongly referred to as Sadar PS case number 202 within bracket 8 of 2022. Come on, the submission made is duly noted. And nothing is required to be mentioned. I think it will not have any consequence.
No, my lord. Just
My
my lord, for my satisfaction. Stop.
It is further submitted that this matter be taken up after the petitioner receives a copy of the charge sheet filed in the above case. In view of the submission, release this matter. When?
Lordship, 3 weeks.
This is the matter after 3 weeks. You are appearing for?
For respondent number 1, your lordship.
Respondent number?
1.
Respondent number 1 is the state.
No, my lord.
Sheikh Mohammed Ashik, your lordship.
Why this case is so and so versus state of Meghalaya?
No, 3.
Yeah,
My lord,
you-
I think my
sorry,
there is.
Your Lordship. Response number 3.
Is number 1 is state?
Yes, my lord, friend is for 3, my lord.
Hmm?
3 and 4.
Yeah, state is number 1. You are
Yes,
appearing for?
Yes, Your Lordship.
You.
Respondent number 3, Your Lordship.
Lesson number 3, so it's not is. No.
My lord. No, 3 and 4, my lord. Sheikh Mohammad Asik and Ruxana.
So you will appear for
Respondent number
3 and
3.
4.
Only 3. You sure?
You do not know you are appearing for whom?
Only for respondent number 3, Your Lordship.
3 and 4. 3 and 4. 3 and 4. Chalo. My lord.
3 and 4, Your Lordship.
Mr. Mansoori appeared for 3
Yes,
and 4,
yes,
isn't
Yes,
it?
Your Lordship.
Just. At the beginning, you record her presence also. Miss So and so, Lana Council is present for restaurant number. Present on behalf of restaurant number 3 and 4. Okay, you can start this way. In the first line, to record the presence of the participant. Then come to the main part.
Deep level, Your Lordship.
3.
Is there any other matter except this?
But there is one more hearing of my case.
No, if these other matters are short matters, then we will just relieve them. We will not make them wait. Yes.
You see, they are not ready. My friend is saying they are not ready. So maybe
Yeah,
they want to
please, Your
take some
Lordship.
time.
Your Lordship, this item number 13, Your Lordship, the conducting counsel, Ms. N.G. Shilla, she had to leave due to some personal difficulties, Your Lordship. So if this matter can be taken up after.
There also you are.
I'm for the petitioner.
Yes, Your Lordship.
No problem. Just say number 13. You just say on list after
2 weeks, Your Lordship.
on the request of the on the request made on behalf of the
State respondent.
respondents. Yes. Yes.
Obliged, Lordship.
My lord, I will try to shorten my argument and request my lord again to come back to the NCTE norms where
See, Mr.
para
Sangresh,
forest-
what we understand, if matter comes to that, and if in view of the stand, you see, like stand of the state, specifically, 2 things they have said. One is that no advertisement, and second thing is that you do not possess the qualification. Other than that. So if you address on those issues, that will be, I think.
Yes, I will address to that. I'll confine to that only. Yes. Now, Lordship, kindly come to para 4 where learned counsel for the respondent relied of the NCTE norms in my compilation, page number 40. 40.
Yes.
And para 4, Lordship, kindly come to page number 42.
Yes.
Now, it says there is a condition. It is not the case that all the appointments prior to these notifications are not required to fulfill the eligibility criteria.
Yes.
So it says the following categories, it says, categories of teachers.
You are reading which part?
Para,
Oh,
para
yes.
4.
Okay. Yes.
Para
Yes.
4.
Yes.
The following categories of teachers appointed for class 1 to 8 prior to the date of this notification did not acquire the minimum qualifications specified in para 1 above.
Yes.
Number 1 category is a teacher appointed on or after 30 September 2001, that is the date on which the NCT determination of minimum qualifications for recruitment of teachers in schools, regulation 2001, as amended from time to time, came into force in accordance with that regulation. So he must be appointed under that regulation. Then in that case, he is not required to qualify, acquire the NCT norms. Provided that a teacher of class 1 to 5 possessing P8 qualification or a teacher possessing P8 special education or D8 qualification shall undergo NCT recognized 6 months. So this is one of criteria, but we are not concerned with the class 1 and 5. Here We are concerned with class 6 and 8. Now, a teacher B, a teacher of class 1 to 5 with B.Ed qualification has complete 6 months special teachers course, special PTC approved by the NCT. A teacher appointed before 31st September 2021 in accordance with the prevalent regulations. Now, he claimed that he was appointed 2002,
Yes.
original appointment, not prior to 2001. Now, that means he was appointed during the enforcement of this 2010 regulation. Now, it says that he must be appointed under the, as per the 2001 regulation. Now, 2001 regulation is here. Just place one section. If he fulfilled this criteria under 2001 qualification, then he is not required to obtain the NCT norms. Now, when I come to section 3, qualifications for recruitment. What she called it?
Yes.
It says, the qualifications for recruitment of teachers in education institutions mentioned in section 2 above shall be given in the first and second schedules to these regulations.
See, just before this, come to section 2.
Section 2. This regulation will be applicable for recruitment of teachers in all formal schools established, run or aided or recognized by central or state government and other authorities for imparting education at elementary, primary and upper primary, middle school, secondary and senior secondary stages.
So this was made applicable only to those schools.
Yes.
But then 2010 notification applies to all the schools.
Yes.
There is a difference between the
difference. Now, admittedly, if we go by the section 2, Roshi pointed out,
yes,
upper primary school also falls under this 2001.
But then it is aided, must be aided and recognized by the central or it is aided or recognized by.
Aided or recognized by, aided is one.
Yes, or rated.
Or recognized.
Not end.
And not end. So it's a recognized
even if the school is recognized school, then it must follow this norm.
Yes. They may not receive the grant in it, but once it is recognized, and he has pointed out that 2002 permission was granted and recognition was there. Now, immediately under section 2, then our school is under this.
Now, Mr. Sangresho says, supposing if the state has their separate set of rules, then what happens?
My lord, in that case, if it is contrary to this one, this will prevail. My lord, state can prescribe other qualifications, my lord, which is not provided here, but they cannot provide over and above or in contrary to this 2001.
Okay.
My lord, now may I take lordship attention to section 3.
Yes.
Now, qualifications for recruitment of teachers in education institutions mentioned in section 2 above shall be as given in the first and second schedules to this regulation. The qualification prescribed in the first schedule shall apply for recruitment of teachers for teaching school subjects. The qualifications prescribed in the second schedule shall apply for recruitment of teachers for physical education. We are not concerned with physical education. My lord. Now, subsection 2 and 3, not relevant. Now, may I come to the schedules? The next page, the first schedule.
Yes. This matter referred need and have the copy this one.
It is a law. It is a law. I don't need to provide my law to every one of you. It is a law we are referring to. And you are relying on this, he is supposed to know.
He is referring to a notification dated 3rd September 2001.
Yeah, this is a regulation.
3rd September?
3rd September 2001.
Now,
in the schedule, Lordship kindly
this has been issued in pursuance of the National Council for Teachers Education
Yes,
Act, 1993.
Yes.
Now, what the act says? What is the act?
The act is, my lord, here. The act they have referred, National Council for Teacher Education Act 1993.
Yes.
So
where is that act? You have a copy of that act?
My lord, right now it is not with me, but the rule is framed under this act.
No, but then we'll have to see what in the main act.
The main act, my lord.
What is the extent of application of that act?
Right now. Can you check? My friend could please just come up.
Anyway, you continue. You may keep it part hard. We'll continue tomorrow also.
Well, Well, and we will produce also. And Lords, you kindly see the schedule of the regulation, the next page.
Yes.
Now, we are not concerned with primary. Now, for upper primary, my lord,
Yes.
it is there. And it starts from schedule 1.2.1, senior secondary school certificate or intermediate or its equivalent. Lordship, got it?
This is you are reading the primary section.
Yeah, in the primary, this is, my lord, for primary is, my lord, started from, it ended from Bachelor of Elementary Education period. It ended. And for upper primary, it started from serial number 1, 2, Roman 1, 2 again.
So this B should have been somewhere there.
Yes, the way they arranged, my lord. So reading need to start from in the bottom of the. Yes.
Yes.
Now, senior secondary school certificate or intermediate or its equivalent, and diploma or certificate in elementary teachers training of duration of not less than 2 years. This is one of the qualifications he doesn't have. Or Bachelor of Elementary Education, he doesn't have. Or graduate with Bachelor of Education B.Ed or its equivalent, he doesn't have. So my humble submission is the Para 5 saving clause or Para 4 saving clause under NCTE, if he was appointed 2002.
He will not cover his case. He will not cover his case.
Yes.
It will not come to his rescue.
It doesn't come to his rescue. So had he fulfilled this one and appointed 2002, then his contention is correct. He is saved by Para 4 of the NCTE. But since he did not fulfill this, he cannot take the shelter of Para 4 of the NCTE. And that is one, and I'll come to the his qualification additional affidavit, Lordship, which we have referred prior to his additional affidavit. I'll confine to this only and show my qualification, and I'll raise my
Your qualification, or you are showing his qualification?
His qualification, since we are
What is
touching
that?
his qualification.
Just
now, additional affidavit filed by respondent number 7.
okay. What does it say?
Now he has obtained the Lordship got it.
How many affidavits have been filed?
Additional affidavit filed on 20 April 2021.
2021?
Yes.
This became a mess.
A huge pleadings, unfortunately.
These are all, you see, the things which could have been compiled in one thing has been done in piecemeal, depending on the stand taken by the parties from time to time. Yes. Yes. Which page?
Well, Lordship got it. Now, para 3 of the affidavit.
Yes.
He has highlighted his qualification.
Yes.
Para 3.
Yes.
And that the answering deponent states that you are answering the respondent having requisite qualification for appointment of teachers as per notification 2010. He said he fulfilled that one.
He refers to this notification which you have?
Yes.
Okay.
He's taking that.
Okay.
Prescribed for minimum qualification for a person to be eligible for appointment as teachers in class 1 to 8 in a school referred to such and such. Your answering deponent had passed the high school living certificate examination in 1991 and thereafter completed PU Arts in 1995. Your answering deponent also further graduated Arts in 1998. Additional, your answering deponent was also duly passed the District Elementary Education eligibility test in the year 1996 under Meghalaya Board. There he has annexed that one. Now, may I come to the next?
So he doesn't dispute the applicability of the notification which you have?
Yes. Yes.
Rather, he takes support of that to establish his education.
Yes, he tried to take support, but in reality, it doesn't help him.
In reality, if you take into consideration that clause A of that paragraph 3 doesn't fulfill that.
It doesn't fulfill. It doesn't fulfill. And the next page, Roman C, the sub C, in the next page it says when he obtained the science paper. The next page, page 3, may see that your answering deponent had participated for orientation program on language teaching, says, not for science, training on 10 to 19 July 2008 under the government of Meghalaya. Accordingly, the certificate was issued by Sansad Dura. He participated 10 days teacher training under SSA program under block mission coordinator.
Yes.
Mission coordinator. Sansad was with effect from 8 to 24 September 2008. Accordingly, the certificate had been issued. He also participated 10 days in teachers training program under block mission coordinator Sansad on 12 March 2000 to 22nd March 2012. Accordingly, the certificate was issued. So he did not fulfill that 2001 regulation also. Now C is interesting. The reason why, my lord, I want to refer para C. Your answering deponent states that the subdivisional school education officer Karo Hills Dadankiri was pleased to issue no objection certificate in favor of your answering deponent for studies. Right? NOC dated 2014 on obeying the no objection certificate issued by the SDSUO. Your answering deponents admitted for the course of PU Science for betterment of the students, particularly for the school. Your answering deponent, a respondent, had successfully completed the course of PU Science in under NIOS, passed under the secondary examination held in 2016. So much after arrival of the NCTE norms. So, and his certificate is available in page number 21 of that very affidavit. So my humble submission is that, well, he is not saved by para 4 of the NCTE norms. He himself is not eligible.
Which way it proves your case.
Yeah. Therefore, even if assuming that NCTE norms is applicable, I also don't fulfill, I admit. So also he also doesn't fulfill. So both the appointment will go.
If you say, like, if he gets the advantage of wrong, you should also get the advantage of wrong.
My lord, therefore my humble submission is.
So can it be a legal submission?
No. Therefore my humble submission, is NCTE norms is not applicable. If lordship satisfied, then lordship may appreciate. If lordship do not,
there is no concept of application of negative.
Oh, that is true. Negative equality.
The benefit of wrong cannot be extended to
Exactly. So, if NCTE norms is applicable, I also fail. So also he also fail. Since I have challenge, if I don't challenge his appointment, then
now, who should fail? It is the prerogative of the state authority to take a decision.
My lord.
Now they have taken a decision to fail you, not him.
That is why he removed me and appointed him, and I challenged his appointment. Therefore, and lordship, I brought before lordship jurisdiction. Lordship is sitting in an equity jurisdiction. And now, when the wrong is brought before lordship.
Now, this court wonders one thing.
Yes.
You see, now, your removal and his appointment in that place.
Yes.
It happened after considerable lapse of period from the date of your original entry in the service. It's 2014, isn't it?
14.
For him, it is 2002.
Yes.
And then your exit from service is 2017.
2018.
And
18.
his induction in that place in 2017. Yes. Saying on the same day.
Yes.
Now, if your continuation in the service, both of you,
yes,
if you have continued under the SSS scheme. Now, as you say, the SSS scheme comes with a sanction number of posts. Now, all along, during your continuation as well as his continuation in service, if you all are serving under SSS scheme, those posts were fulfilled, isn't it? Right. Now, in fact, admittedly, the respondent number 7 also was holding a post under SSA, maybe in the different stream, in the language stream, isn't it?
Yes.
Now, what is the purpose of shifting him from that stream to your stream?
Science stream. Science stream.
Why that has been done?
My lord, to remove me from the science stream and accommodate another person in the language department. He was already in the language teacher, as a language teacher.
So that person is also a party here in this case?
My lord.
Okay, you have no knowledge about who has been...
Yes. He had just point out in the
The
affidavit.
purpose was that to vacate that position so that another person of their choice can be accommodated.
My lord, he has taken over mine. He was, if he was shifted from headmaster only, situation would be different. But he was already adjusted in the language, which is one of the sanction posts under SSA. He is supposed to be satisfied with that. But the problem with him is he doesn't want me to be in the school. Therefore, he acquired the PU, the science paper also 2016. And the moment he got the qualification of science under NIOS, he got the appointment in 2017. So how can he claim that his appointment as a science teacher is will fair from 2002?
No, when did he acquire that qualification of science? In 2016?
2016.
April 2016.
Yes.
And when did he enter into agreement with you?
My lord, that one, I'll just...
It's sometimes August in 2016, after
yes.
this.
Yes, I'll just...
Probably.
I'll just reflect again. Yes, that is 28 October 2016.
So after he acquired this thing.
Yes. Now
so he enters into, so it cannot be said that he acquired this qualification to oust you. Because thereafter he has entered into a compromise.
Well, I'll just refer to his qualification.
And you are taking shelter of that compromise also.
Compromise
to support your case.
My lord, to show the conduct between the two, understanding between the two parties. But that his qualification his
Now,
qualification, my lord.
This
Marksheet is there.
This man, the response number 7, after he acquired this qualification of PU science,
yes,
did he become suitable under this notification?
Still then,
could he? I mean, like, was it a fulfillment of the deficiency?
NCT norms? NCT norms?
No, even not.
Not at all.
Not at all.
Not at all.
So even by if you take into consideration that also, then
Yes.
also will not bring him in the zone of qualification.
Exactly. And this agreement was reached before he acquired the qualification. He acquired the qualification on November 2016. His qualification.
He appeared exam in April 2016.
Yes, appearance of exam. So even assuming that his qualification is relied upon, it doesn't fulfill the NCT norms. So it doesn't help him also. So my humble contention, my lord, I'll show my affidavit, the mark sheets, and I'll raise my argument with the citing 3 judgments only. My lord, in my rejoinder dated, rejoinder to respondent number 7.
There's so many documents.
So many pleadings.
Even if you note also become confused, you see.
Right.
The rejoinder dated?
Rejoinder dated 2nd October 2019. Second or 10th?
There is nothing to second. There are
rejoinder to respondent number 7. My lord got it, this the copy, the rejoinder. I filed how many rejoinders? Number 7, Lordship kindly look to respond to affidavit of position filed by number 7.
There is a rejoinder in response to affidavit.
Yeah, 1 to 3
filed
also.
on 21st October.
Yes. October.
21st October.
21st October.
Okay. With
My lord. And my mark sheets may come to page number 12. Page number 12. They say that I failed in mathematics. That is, they have mentioned in the impugned order. I want to show that I did not fail. So how they reach to a conclusion that I failed in mathematics also. Page number 12.
Yes.
The mark sheet I have given.
Yes.
My lord. So on the top, alternative English is there. Now physics, chemistry, biology, and mathematics. Mathematics are 35 marks. And
Just where is that physics, chemistry page?
Physics, when we read in this way, man, when we read this is alternative. The physics is table 1, 2, 3, 4 table. They write PH.
See, there is a table is there. It's
the table is
elective subjects.
Yes.
4th subject.
Yes.
Now in the elective subject below that.
Yeah, PH means physics.
Yes. Then.
Physics. And chemistry, CH means chemistry. And biology.
It starts with English, MIL, theory.
Yes.
Practical.
Yes.
Then theory, practical.
Physics.
Acha, CH. Okay, that's right. Just near the mark.
Yes, near the marks.
Okay, and where is the mathematics part?
Mathematics, Lordship will come down. M. The 4th subject.
Yes.
4th subject. He secured 35. So
what is the 22 below that written?
My lord, full marks pass. This may be a pass mark. 22 may be pass mark. Now total he secured 248. He got second division.
The pass mark is mentioned nothing.
Yes.
Before that, full marks 30, pass mark 10. Theory, full mark 70, pass mark 25. In the 4th subject tabulation you find it.
Yes.
Now full marks is 100, pass marks is 35.
35.
But then you got 22.
Lordship got this.
Below is a 22.
Below 22.
So you failed.
Below 22.
You failed.
Now
you failed.
Yes, this is mathematics. Mathematics. But now the question is, my lord, whether the rule provides that there is no rule as such that a person who failed in mathematics should be considered as a failure.
Okay, but then you wanted to show us this mark sheet to show that you passed in mathematics. So the fact remains that you have failed in mathematics. Otherwise, fact remains that you also do not fulfill the NCT norms.
NCT norms of data
that is what. So
that is undisputed.
This is that way. See, like that is nothing. It is admitted fact. You have got 22 only.
Yes. So he got second division in BU. Only they say that I failed in the mathematics.
It was your 4th subject, so it was
it's the 4th subject only.
It was not much material so far as your result is concerned.
Exactly. If it is not the 4th subject, I fail.
When it comes to determination of mathematics, then it may become material.
Right.
Now, whatever the fact remains is that the qualification should have been as per the NCT norms. Whoever, for you or for him. Now, admittedly, if it is the case that his ouster is because of not having qualification as per NCT norms, he could not have replaced you because he also doesn't have.
Right. Exactly.
So, you see, if their intention basically was to bring in some qualified teacher, they could have done, but they have not done it.
They could have done.
So, your removal is malafide, apparent with intention.
Right.
To accommodate somebody else.
Correct. Lordship got it exactly.
So that is what comes to probably your submission.
Right. That is the substance of my case. I cannot be replaced by wrong person. If I am wrong, I should be
that
removed.
is what. So there is no basis. You see,
no basis.
If they have detected the wrong person, wrong in your qualification,
yes,
they could have replaced you by a right person.
Right.
But then they have not done.
Right.
They have.
Correct. That is the case.
Anything more?
My lord, only that one. I may just cite 3 judgments and I will close.
What for? This is what judgment with regard to what?
My lord, issuing a show cause notice when the employees.
No, but then here it is admitted that you do not have that qualification. So that is once, see,
but
the law is that the principle of natural justice will not be attracted once you admit. So that is the admission, your mark sheet says it. And you are also at the hearing, you are not disputing it. So
but yes, when it comes to NCT norms.
Just what requires for this court to examine is that whether your replacement by another wrong candidate was proper or not.
Yes.
And if it is not, then order should be quashed, matter should come back to its original.
Original position.
Original position. Take action accordingly.
Yes. Original position. Now they have taken another plea that I did not file an appeal under the Meghalaya Education Act. Now the Meghalaya Education Act is very clear. It is only the managing committee who has the power to terminate, remove the employees with a prior approval. Now, no prior approval was obtained. They remove me, disqualify me, managing committee, and subsequently approval after my cancellation comes. And I came here because there is no issuance of show cause notice. Therefore, there is Supreme Court.
See, managing committee doesn't terminate your service. They only take a resolution. Okay. Once the resolution is approved, then only they issue their termination order. That is what you see. Otherwise, the state of its own will not remove you until unless they have information to do so.
Right.
Now it is the managing committee who is not satisfied with you.
Yeah.
So they take one resolution to remove you. Now they will not pass this resolution, remain in record, and they will not pass any order. They will not pass any effective order so long that resolution is approved. Once it is approved, then they will pass. That is what the meaning of this.
My lord. And they are not issuing any removal order. Managing committee.
So it is only the resolution which was approved.
We were approved by the STAs, Joint Mission Coordinator.
And then if they themselves pass the order,
yes,
then it's okay. Then this is appears the apparent fulfillment of that.
Yes. But therefore, the procedure for removing a person, it is not fulfilled. That is the judgment.
But then in that case also, you cannot say that appeal will not lie.
No, therefore, the Supreme Court 1999 Supreme Court decision say that when an employee is sought to be removed on the ground of appointment contrary to the rules or act, the first step is to issue a proper show cause notice as to why you should not be removed because you were appointed in contrary to the rules. That should be given. And
but
if it is not given, then the removal or termination is bad in law.
But in their case is that you were never appointed. It's a provisional approval.
Well, all of them are provisional. They use the word provisional. Some they use approval. Mr. Sundarai, 2 approvals are there. 1 approval, 1 is provisional. So these are on the language only. There is no second approval, no final approval. This is the language they use only. Once it is approved, approve. So once I'm approved, right or wrongly, to remove me, then at least some semblance of fairness should be followed. That's what the 1998 Supreme Court says. I will not drop on my lord. I have placed it, these are dates and citation I have submitted.
See, there appears to be no quarrel with the subtle proposition of law. Okay, if you are taken into service, if you are into permanent service, and if it is subsequently found that your very entry into service is in violation of certain norms or the rules,
yes,
in such a case, show cause is issued to you.
Yes, show cause issued.
And then you are removed.
Yes.
Now, here it's a case, if you have provisional approval, that would mean that your contingent is temporary. In such a case, full requirement of following those things is not required.
My lord, if there is it is only provisional, there is no final approval. Not in my case. This is the language they use only. Therefore, he said for 1 approval and second provisional approval comes to him also. So once I was born, right or wrongly, to remove me.
Let us see what the state, how state clarifies that about.
So therefore, I don't need to file an appeal because if a person is removed without issuing show cause notice, then one can come to this sort of court.
Natural justice, and
yes,
then
one can invoke my lord jurisdiction directly.
Yes, Mr. Kharmi, you first satisfy us on with regard to your approval of provisional and all. Second thing is that you have removed one person on the basis of not having requisite qualification, and you have taken another person who also doesn't have requisite qualification. Which way you answer that?
Lordship, the qualification is as per the norms, NCT norms. So as per the NCT norms, Lordship, both of them, they do not have the qualification. As per the NCT norm,
that is a common stand. That goes as a common stand.
Yes. So NCT norm says qualification is secondary, senior secondary, and 4-year BA, BSc.
Then how do you justify? How do you justify that Respondent number 7's appointment in his place?
Yes, Lordship, because his appointment was appointment of the petitioner. It was provisionally approved.
That is all right.
Because
we understand. Okay, he doesn't have a case. Yeah. How you have taken him in his place? Why you have not gone for a fresh recruitment of a suitable candidate?
Yes, Lordship, the appointment of the, if you go to the appointment of this petitioner, Lordship, you'll see that his appointment, it was made because there was no science and mathematics teacher. So it was made, he was given the
You are
appointment.
talking about him.
Petitioner.
That is all right. We understood. That part, right now, there is no confusion for the court. We can understand what you say. We accept it also.
Yes.
That yes, there was no science teacher.
There was no science.
You have taken him into provisional.
Provisionally. Yes.
It's all right. Now you say that he doesn't have a qualification, you throw him out. Now, in his place, how this person comes? See, you have to justify it. Otherwise, there will be imputation of malafide.
Yes, Lordship.
Then we will say that you have removed him only for the purpose of accommodating him.
Yes. Lordship, then, Lordship, I'll go to this resolution on the basis of which the appointment of the private respondent was made.
That has already been read out by Mr. Sangreshwar. This resolution is not helping your case. You are the state.
Yes.
A resolution will not bind you. You have to attach legality to your action.
Because Lordship, in this
resolution doesn't attach legality to your action. Now you have to satisfy how this respondent number 7 has been considered suitable under the NCT.
Because Lordship, the appointment and review of the teachers in this SSA school, Lordship, lies with the managing committee. So under recommendation, Lordship, the department has
Then what for this NCT norms is there? If it is a managing committee, then throw this NCT norms, throw this notification.
Because appointment is done by the managing committee. The department gave only the approval.
Under the SSS scheme, the scheme sanctioning the post and the norms to be followed for appointment, you just place it before us tomorrow. That may clarify things. Let us see whether SSS
The norms, Lordship, it is applicable. This norm is applicable, Lordship. Because Lordship, that government instruction is there.
Then your submission, which way you are making the submission? You take a common stand. You cannot take contradictory stand.
Because this norm is applicable to all the schools, whether private or aided school or unaided school.
Then it means you will approve only the resolution which fulfills the norms laid down there. Otherwise, you will reject it. What made you accept it?
The managing committee should have first verified their qualification before forwarding the recommendation.
But then you have accepted it. Now it becomes your duty to, justify your action. Now if you say that it was done wrongly, we'll record it and we'll decide the matter. We'll just say both the appointments are illegal. We'll direct the school authority to issue fresh advertisement. We'll take it to record your submission. Are you ready to do that?
Lordship, but then I'll just get the instruction. I'll just
Mr. Sangreshwar,
discuss, verify.
What happens? We interfere with both the appointment and direct the authority to issue fresh advertisement.
Well, if my first contention is not sustainable in my Lord's eye, ultimately that situation may come.
Your appointment also is not legal. To attach legality to your appointment is something this court is not very much willing to do.
Right.
Now, so far as that part, because your removal is because of the induction of the Respondent number 7.
Exactly.
Now, that is where you may have a case. So, it is not a very simple thing that you found not suitable and he been found suitable was taken to service.
Right.
It is not a case.
Right. Both
They
appointment
out you and then bring you.
Yes.
Okay. Now, this is one aspect.
Yes.
Let us see what he says. We'll have it tomorrow.
Yes.
We can have it tomorrow.
Tomorrow, Lordship. Day after tomorrow, Lordship. Day after tomorrow.
This court has a very short memo, you see. This is problem. But then, of course, we have to hear Mr. Devnath.
Tomorrow, I'll get instruction. I'll obtain the instruction tomorrow.
Okay.
I'll
Let
call
us
up.
see. Yes, Mr. Devnath. What you will say, Mr. Devnath? How you will justify? Now, do you dispute the fact that you also do not have the qualification as per the NCT norms? Because see what has been referred to by the learned senior counsel here. Your affidavit, paragraph 3A and B onwards. It is apparent you do not have.
You receive here, my submission is here. when this school has come into this under the NCTA norms, and that point of time, if the prior to that, the period when I appointed, and that.
What is your original appointment order? 2002?
2000, prior to the appointment order.
First appointment, your first appointment.
It is not annexed.
Hmm?
It is not annexed.
No, you place it on record. If you want to have with these things any advantage, if you can show it that you have come into service before that and not that time this norm was not prevailing, you may have a better case to defend.
Regarding the appointment of private respondent, he's representing private
The
respondent.
first appointment, not that recent one.
Yeah,
That
he's
2002.
representing, he'll be in better position.
So I have to call for this. I have to bring this record.
You have it or not?
At the moment, I don't have it.
No, forget about here, whether the party will be having or not.
A party will be having everything. Because this.
So we'll place it day after tomorrow?
Yes.
Day after tomorrow.
It will be difficult. I have to bring some parties.
Then
They
this
can send through
entire
WhatsApp
time
only.
will go on with this is the thing. Because now we may not go into, you see, like if you had to go by the entire things and the documents which have been annexed to support the claim and counterclaim, you see, that may not be required in view of the matter coming to the qualification part. You see, that is what. You see, it is not that, you see, whatever a particular person thinks or particular officer thinks, then who should be carried on or not. There is a law holding there in. So once we find that the appointment is with this, appointment is accordance with law, we will not interfere. Otherwise, see, your sufferance will be more because you are in service for a long time. And if any order is passed interfering with your service, then you will be nowhere. There should have been a better way of projecting your case because now your own admission makes it difficult. Your own statement.
He was appointed in 2002. As per that paragraph 4, Lordship, candidates, teachers who were appointed prior to the 2010, when this notification came to force, they need not acquire the
provided
qualification.
provided they fulfill the requirement which was placed.
Yes, provided they fulfill those requirements.
Let him produce on day after tomorrow. Only one page order, they may send through WhatsApp to him and he can print out and place before the school. Not entire record.
Let us see.
We'll
keep this matter parted.
Yes.
I'll obtain this instruction.
Yes, you just take the instruction. This court is not passing any specific instruction, specific order with regard to the instruction.
Yes, sir.
You just keep it in your mind, you obtain it. We'll
Yes.
just keep it parted and we'll have it day after tomorrow.
Yes, tomorrow. Yes.
Yes, hard in part. List. Again on, just give, what is the date? Hard in part, list on so and so for further hearing.
Yes.
This becomes a mess, you know.
Yes.
If our,
Yes.
we do not know, but then this is the state action which basically creates this mess.
That is
They go on approving whatever they.
that is that is
If the people occupying the position in the managing committee, and if they are in good relation, they will not see any legality along those things.
Second case also,
they have a role, managing committee also, because they pass one resolution after another and forward to the government.
They have a role, but then to attach legality to their these things, you are there, you are superior
Yes.
to them. You are not bound by them. If they say that you appoint somebody who is not even matriculate, will you appoint? Then
They have to verify.
see, all authorities have some responsibilities attached to their own part.
Right.
item number 4 also, my lord.
4 is
In the connected matter.
So this
The
also
second petition I
connected
challenge.
matter means this hearing or decision in this case
Yes.
will whether that will have the
Yes, in the second petition, I challenge his appointment. In the first petition, I challenge the managing committee resolution. Second, I challenge his appointment.
this is the first one.
Yes, this is the first one.
But then anyway, once we have started, we have to finish it. We'll just give a try. Just see Friday if we can conclude on Friday. But then this matter will remain part of it.
Yes, Lordship.
That is for sure.